Yes.
One petition matter, 1373 of 2025 now, wherein I am respondent number 6 month. I have been authorized by the respondent number 6. In the meantime, he died now. So I shall have to inform the petitioner that the matter come for whatever.
Matter pertains to,
Matter pertaining to land acquisition matter. There is a RSA pending also.
item number,
No matter mentioned,
mentioning for what?
mentioning for orders matter,
Why?
for substitution of the legal head of respondent number 6.
Have you filed that?
No matter my pertaining before the lot is that the respondent number 6 died matter. I shall have to inform the petitioner sir. Otherwise, my lord, matter will be delayed matter. That's right.
How does it have relevance?
Relevant matter, land has been acquired, madam. Acquired, there is a RSA pending, madam, in between the petitioner and the respondent number 6.
Inform the council. Why should you inform through the court? You file an application that response petitioner had died or response number 6 had died. File an application, it will come up.
Of that,
Item 15, my lord, there was an affidavit file, my lord, we were supposed to take instruction on that, my lord. But we could not contact the client, my lord, and further, my lord, S. Bonik, my lord, he is in bereavement. But he
What happened?
suddenly, my lord, today only maternal uncle expired, his maternal uncle expired, he has to travel to Shillong. But may I pray, my lord, that Tuesday, Lord, by that time we will get the instruction also, my lord, on the affidavit. I have taken
It
consent.
has been submitted that Mr. Asbury Bonik is in bereavement on account of the death of his maternal uncle. Considering the above, the matter stands adjourned to be listed again on 27th of November 2025.
I'm obliged.
so that's it. I have to mention for listing one WPC on Monday.
Why?
Matter relating to the eviction of the petitioner from the homestead Batta land, due to construction of
Huh?
eviction of the petitioner.
Bench 5.
Yeah, please, your lordship. Lordship, listing for a petition on Monday, lordship.
Huh?
Listing for a writ petition on Monday.
Monday.
Yes.
Why?
Next week, any date next. These are the students of law final semester, and their examination was stopped by stating that they have used some unfair means, while their AIB examination was to be held on 30.
You want to move a motion?
Yes, lordship.
When? Tomorrow?
Next week, any date. Next week, any date.
Okay, next week you file it. You want
Lordship,
to move it tomorrow, then tell me. Have you filed it or not?
we have filed it, but it has not numbered yet.
Huh?
We have filed it, but it has not numbered yet.
Not numbered.
Not.
You want to move it tomorrow?
Okay. Okay.
Item 1 and 2, part heart.
This issue lordship has been raised by the Madhya Pradesh High Court. Same matters lordship. Division bench has already held in favor of the SSC, which may. Give the judgment. Same NMFP scheme lordship.
Please, your lordship.
So what are your facts?
Lordship, may it please your Lordship. Lordship, in both the matters, my senior brother will appear, Lordship. That's time. From central government, oblige, Lordship.
Mr. Chakraborty, you have not filed your reply. So we will assume that you have nothing to say. You are bound by what you'll be bound. If they are entitled, you have to pay. Your thing is that you delinked it. Huh? No, no, you delinked it from the central, giving the year, but in the meantime, prior to that, you have already transferred the share to the state. That is what appears to be what has happened. Now, if you have transferred the share, it will be now the burden of the state to make the payment.
Provided they are ready. Provided they are ready.
Provided they are ready to, that is why the petitioner is here. And if it is not there, because it is your scheme at the end of the day, you have delinked it, it's a different thing. Administrative convenience, you have delinked it and given it to here, but it is under the aegis of the central government, it was done. So any money which is to be paid by the state, how you take it up with the state is different. But this court, if the petitioner is entitled to, this court is going to pass an order to that effect, whatever the dues are. Because what I see in the case of Mrs. Saikia, that on a particular date, much after that, sometime in the month of August, they had taken up the matter. But for some reason or other, they did not do it. But in respect to other industries, they have done it, but not for her industry for whatever reasons. And they, on a particular document being not there, which on the face of it was not tenable, they have not considered. So therefore, the petitioner here has approached this court of Madam's matter. And what is your case?
Lordship, my case is that, Lordship, my state level empowered committee had dealt with my matter. They, while dealing with my matter, they had informed me that I have given all the papers and documents. There was a difference between the bank appraisal report and the CA certificate which I have given. There were difference in the figures. They pointed it out to me. Immediately I had, Lordship, given the clarification and I had written to the bank that there was a mistake in their appraisal report. They had also corrected it and we have given a certificate within 10 days of the knowledge. Thereafter, Lordship, the empowered committee meeting was not there. They could not sit. And we informed also that why are you not sitting in the affidavit? They are saying that since the dealing, it has been delayed, we are not setting up the state empowered committee because it has to be routed through state empowered committee meeting. Like in the lots of other subsidy matters, state level committee meeting sits. Over here, state empowered committee meeting sits. So they have to approve my claim. The committee meeting was not held thereafter. Because thereafter they said that it has been delayed, now we will not be able to process the claim. Otherwise, my only difference was there that there was a difference between bank appraisal report and the CA certificate which I had submitted before the authorities. Which I had clarified and they have asked me to clarify.
Madam's case is that particular CA certificate was not given,
Yes.
which was, however, the general managers have given up categorically that all the documents have been duly submitted.
And we have received it subsequent to 31st of March 2015, after the delinking by the central.
No, that is the second certificate. That is the second certificate. The first
No, that-
certificate was given on.
No, that is our stand, I'm just placing.
You have given us then, but how do you explain the general manager's letter?
there-
That is your implementing agency.
Not true.
So therefore, the fact that the petitioner submitted another CA certificate does not make that the petitioner did not submit the earlier certificate. Because the petitioner stand, I think that is at page 27 of her matter. What is your matter, Madam Titabor?
No, Titawar,
You have Titabor,
no.
Bina Bakers. Bina Bakers. Bina Bakers is here. Bina Bakers is page 27 is what was mentioned on the last occasion.
Yeah, my lord, the CSRT is also given. 2014. Gentlemen. This was the bonds, where my lord, every, including COT bond, affidavit, and everything was submitted. CSRT.
Where is that document where you have given? Yeah. The unit has submitted all required documents as guidelines of
Four
the.
and five.
This is at page 43.
43 years.
And this is the bonds. Where CSRT is also available.
So this was submitted in the year 2014
14.
itself.
14 itself.
My lord, page 44 is the CA certificate which the petitioner claims that, my lord, they have submitted in, it was issued on March 2014. Page 44,
Page 43.
44. Down below, Lord, you will see the date.
That is 25/3.
Yes.
And this
There's one more
general
that-
manager gives it on 29/3.
Huh.
Isn't it?
25/3, yes. There's another certificate was again, my lord, placed by the petitioner. Which is
The second certificate is by another CA
another C.
because you must have lost it.
That, my lord, no, nothing is there in the.
No, there's nothing out there, but the fact that when your general manager categorically says who is your implementing agency, the person who has the right to receive it, he says that everything was there. So can you now, and they take a plea. The petitioner again submitted another CA certificate with another aspect of the matter. But for that, it is not the fault of the petitioner here.
No, my lord, the ground, well, page 75 of the petition, Lord, so you will see, it's part of para 8. Para 8, my lord, after the chart.
Mhm.
It says.
And
my
on
lord,
19/5, on only where
Yes.
the application could not be placed as it came to the notice of the authorities that the petitioner has already availed two other grants under the Ministry of Food against the same unit, which was not allowed under the aforesaid scheme. It is stated that after the aforesaid meeting dated, no further meeting of the committee for sanction of the financial assistance for category of 25 was held so and so. Now, the question is whether the petitioner is entitled for any, it can't be for a CA certificate. Now, here there is an,
Yes, the ground now is, my lord, already availed, my lord, that 39 lakhs or something earlier. Whether he can, my lord, again, my lord, yes.
This is an expansion project.
Expansion part whether he will get or not, that was the clarification sought for.
Scheme itself, yeah. Scheme itself, well. The CS certificate is page 44, that horizon itself. Same person.
So now your only ground for rejection is that the petitioner has already availed.
That is what appears from the, my lord,
This part 32, my lord. This
Page?
is-
affidavit.
This 32. Municipal organism, first C. My lord, first to eligible objectors.
Hmm.
As a
Yes.
object, the main object.
Yes, yes.
So on. It is the level of.
Which paragraph, madam, you are reading?
One. Page 32.
The main objective of the scheme is to increase the level of processing, reduction of wastage, so and so, so and so, so and so. And expansion of existing units in the country.
An expansion.
So you come under the 50%.
It exists. It was existing.
Of plants and machinery, 50%. Pattern of assistance, 50% of the cost of plants and machinery and technical areas subject to a maximum of 100 lakhs for so and so. So this is for the 12 plan. Now, have you taken the benefit of this scheme earlier?
Earlier, while setting up the mechanic first time, my lord, it came up 39 lakhs. Thereafter.
Then is it the mandate that you are not going to get it?
Perhaps, my lord, that is,
Huh?
that I don't find in the scheme.
Then how can you take it?
Turn machineries. Then plan, then avail some.
And my lord, that part will have to be clarified by the central government because it is their scheme. Whether they can avail the, my lord, benefit for the second time in the name of expansion and modernization.
Yes, it is the objective is so guideline.
No, it is category given on top.
yes.
Guidelines for implementation of the scheme for technology upgradation, establishment and modernization of the year. It is already there.
Objective also is very clear.
Ambiguity.
And even, my lord, para 3, page
We have
32.
got the scheme where that day somebody gave me that scheme.
Yes, I have given it, my file also. And that's given. Otherwise, why they will leave general manager for audit? They have understood the scheme.
This is it, guidelines. So the guidelines fully show that there is anything out there, state level, structure of the state level, funding, criteria for allocation of funds. All states may advise not to exceed the total allocation of one.
Is it for instance?
It was my affidavit. Affidavit of application, I was on- এখন affidavit কার লোক আছে? Second affidavit. এখন না। Additional affidavit. এখন পিছন। এখন পিছন পিছন দেখ। 16
Person out of station, maybe the asset.
Finally come to number 3 of that scheme,
Yes, sir.
eligible organization.
That's why that was, I was pointing out, my lord. Last part says, my lord, more upgradation, modernization of food processing. Units which will be eligible financial standards. Engage in establishment upgradation, probably upgradation, modernization they will come.
in page 35, my lord, is written what was earlier and what was put after this scheme, my lord. 70,000 case they are corrected. Still.
Kindly come to this. Uh, Ru- 9 Roman 17. An affidavit duly executed on non-judicial stamp paper of rupees 100 or more duly notarized by EA, affirming that the organization's sister concern, related company, group or EA itself availed any financial assistance for a food processing project in the past from so and so or not, and if your organizations have not obtained, applied, or will not obtain any grant subsidies from so and so. Fine. So there must be somewhere.
No, these are the declaration that will have to be made. But my lord, having declared that, my lord, they have obtained it, that they will not be eligible. That part, my lord, will have to be there in the scheme, my lord. That is this is a declaration, my lord.
So that ground cannot be good ground.
That, my lord,
Paragraph 8.
That's central government must clarify, my
Central
lord.
government has no
Their
problem.
scheme,
So they will pay you the money you pay them.
No, in the present case, my lord, the affidavit that is enclosed to the writ petition, which was filed in the earlier batch of writ petition. There, my lord, we have stated that in August, my lord, there was a meeting after delinking of the scheme. And, my lord, it could not be considered because there is some discrepancy regarding that, my lord,
But that ground which you have taken in paragraph number 8,
Yes.
that is what is mentioned.
So, lordship, at best, my lord, if at all it is reverted back, the authority will have to consider this aspect that whether if a particular, my lord, let's say in the case of the petitioner, if they have availed the benefit earlier, in the earlier plan, now in the 12th plan, my lord, whether they will be eligible in the name of modernization and upgradation second time.
Why should we allow that? Because of the
No,
fact that,
without there being a consideration.
no, without there, nothing in the scheme to that effect. Why should I allow that consideration?
No, my lord, it will have to be ultimately scheme says, my lord, it will have to be recommended by the state level committee.
No, they may do so, but
Yes,
there
some
has-
consideration
I
will
will
have to be there.
just make yours, take it as your submission and reject it. Then it is closed for them to look into
No,
that.
my lord, I, without any instruction or affidavit.
No, you make the submission. You have made the submission, I reject it in my order. That this cannot be unless the scheme was there. So
Because, my
therefore,
lord,
that,
nowhere the
that
scheme
chapter is
provides.
closed insofar as the petitioner
Yeah,
is
it is there
concerned.
in the affidavit also, my lord. In fact,
Huh?
that is the ground taken in the affidavit. that
So
that
you
is
have
next.
there, so that
Yes.
cannot be a ground unless and until you show
In the scheme,
that. Now, the question is like this, these are guidelines.
my lord.
I'm asking you, these are guidelines.
Yes, to implement the. scheme.
Where is the scheme?
Yes, that's, the entire scheme. I'm not saying anything. No, but scheme has been.
No, this is a guideline. Where is the scheme? Guidelines for implementation of the National Mission of Food Processing for the remainder 12th plan 2013 to 17. This is guideline.
Inside, my lord.
Where is the scheme? I'm asking. These are all guidelines. Guideline, is it based upon some policy? Where is
Why
that
not?
policy?
There will have to be a scheme, my lord, then
There
the
has to
guidelines
be a
will come.
scheme. These are guidelines only.
This booklet is.
These
not a-
guidelines are issued by the Ministry of Government of India, Ministry of so and so. Where is the policy? Let us see the forward. What is this written by? Indian agriculture made rapid strides and so on. This has given rise to much awaited focus on so and so. Therefore, food industry and so and so are not. They are taking a signal by launching the national. We have to look into the National Mission on Food Processing.
Yes. National Mission of Food Processing. 12 plans.
In deciding their priority for attracting investment in post-harvest infrastructure and allied area. It is our hope that the state governments will accordingly prioritize various sectors suited. New ministries news of launching national mission on food processing will enable the states to identify their priorities. These are guidelines. Guidelines for any year and for the remainder. Let us see the guidelines. Guideline. Objective to promote facilities for post-harvest or to undertake so and so to augment the capacity of food processor to support establish self-help groups capacity to raise the standard of food safety to augment to provide better structural level. The mission will be governed by the national area headed by the honorable minister of so and so. The representation of the state governments at the level so and so, administer so and so, structure at the state level, carry out the administration of the state government with our state area will be by the state government under the chairmanship of the chief secretary, having representative from other concerned and team proper by so and so, the state food department, funding pattern. The scheme will be implemented as a newly centrally sponsored scheme in all states in the ratio of 75:25, except for 90 northeastern where the ratio will be 90:10.
Right.
All UTs will be funded on 100% grant basis. So it is 90% for them,
Yes,
10% is yours. Criteria for a Ministry of Area will be transferring the funds to the states only through the states in budget, UT budget, implementation of so and so. According states are requested to. Madam, you have given me something which is half.
My lord, in the first read petition, item 1, my lord, the guideline is there, my lord, entire guideline.
Where?
It is at page 25.
Having my lord.
2811 of 2019. My lord.
Here, page
Yes, yes.
28.
Yes,
You
ma'am.
kindly come here.
My lord.
Funding pattern, here, number 4, page 30.
My lord.
Criteria for allocation of funds, this is page 31. The norms will be reviewed as and when the full scheme of year for remaining period is approved by the competent authority. Components of the memo to be implemented during so and so. Technology upgradation, cold chain, so and so. Component wise allocation of funds. Here will be competent authority to decide intersay of funds amongst them. However, not more than 10% and 20% of the allocation will be prioritized. Will decide the level component to afford project specific so and so. Recall of the grant, SLC will have the authority to recall conversions with schemes of the state. Benefits under this scheme can be given. Now kindly see number 10.
My lord.
Benefits under this scheme can be given in addition to benefits under the scheme of the state government, if any, at the discretion of the state government SLC. Each state may design state-specific schemes under which additional benefits can be provided in addition to so and so. Will submit the utilization survey timely in prescribed format in so and so. This is how it is. Now, objective of we are concerned with modernization. Objective is upgradation. Eligible sectors, eligible so and so, financial grant. And one is now here it seems a bit different. The scheme envisages financial assistance to food processing units in the form of grant in aid at 25% of the cost of plant and machinery and technical so and so, subject to a maximum of demand in difficult areas such as so and so.
Page 35, Lordship is looking at page 35. 35, Lordship will see, my lord, guidelines
So
for.
this seems to be a bit different.
No, 35, my lord. Guidelines for implementation of scheme of technology upgradation, establishment, modernization of food processing industries during the 12 plan. Page 35.
Hmm.
Probably it will be the,
Serial number 3.
yes, my lord. And again, at page 91, another guideline has been enclosed, annexed. Page 91. Same, my lord, 12 plan.
This is the next one. This is the remainder period. We are
Remainder of
concerned with
plan.
this one. So here the difference is this. If you see, funding pattern, here you have this 90-10 business,
My lord.
number 5. Then schemes to be implemented under the mission during so and so. Here kindly see. Number 7, schemes to be implemented under the mission during 2013-17. Measures, program schemes to be implemented under the remainder. The scheme for technology upgradation, establishment, modernization of food processing unit. Scheme of cold chain, setting up of modernization, expansion of abattoirs. So this is what is being to be implemented. 7.1, 7.1.1 Roman 1.
My lord.
Now, administrative expense for years, states may utilize 5% of the actual expense incurred in the financial under the IMAN by the states. So and so meeting administrative expenses towards supporting year procedure for approval. Review, evaluate the implementation of the scheme in the state. They will also ensure physical verification of the projects, assisted concurrent evaluation as well as the submission of monthly progress reports to the ministry in SOF. The area officers of the ministry will also participate in the meeting of so and so. Ministry of Food Processing may also be evaluated, recall of the grant, conversions with the scheme. So if they get any scheme from central government, state government also, that
Yes,
can be permitted.
That is there. But my lord, here the ground is, my lord, from the central government, whether twice, my lord, they can. One during the setup of the industry and thereafter modernization in the next plan.
But that is nothing given.
Yes. 7.1.2 says, my lord, about another guideline, salient features of the guidelines to be followed by the state union territory government for the above scheme mentioned are enclosed.
Flexibility to bring about.
10 says, my lord, procedure for approval. Ten point two says, my lord, state mission directorate would ensure identification of beneficiaries in the respective states and union territories for various schemes of so and so during so and so. They will also ensure physical verification of the project, assisted concurrent evaluation as well as submission of monthly progress, report to the ministry in soft and so and so. Area officer of the ministry will also participate in the meeting of so and so. They may also help in monitoring.
What is the deviation proposal? Yes, Madam Havalia. What is the deviation proposal?
So to take up new schemes.
Thirteen point three point one says, my lord, that the state government can also, my lord, have their own schemes.
We're given flexibility to take up a new scheme.
Yes, but in case there is any
Components not
deviation,
envisaged in the guidelines or deviate from the
Yes.
NPA guidelines with
prior
the
program,
prior approval of so and so. So they can deviate.
they can deviate.
But for that, you have to have a prior approval, which you don't have.
But here, my lord, there is no, my lord, state government scheme, my lord.
Understood? Kindly come to page 105. Twelve.
Yes. ma'am.
So, madam, in your case, this 107 is the problem, no? Kindly come to 107. This certificate which was given, there was some discrepancy with the CA certificate. Then the bank corrected it.
My project was not.
Hmm?
My application was not rejected. We were asked to submit some clarification. Application was not rejected. After they could not process.
No, here, her was also not rejected.
No, my lord, in the case of, my lord, in item number 1, our stand is that, my lord, while considering the, my lord, application, though we sought for some clarification, in the meantime, the government of Assam issued a notification in August that, my lord, we cannot now continue with the scheme because the central government has discontinued. That notification, that communication was issued on 17/8/2015. The scheme was discontinued from by a letter of 27/3/2015 issued by the central government.
But the central government says,
My lord.
while
We can
discontinuing
continue.
it,
from our
That
own issue.
our share which is there, we have given it. They applied when? When did you apply?
On 24/7/13.
For 13 years they have applied. So as per the scheme, you were to do it urgently. Why it took it till 2015?
No, it was a, my lord, 5-year plan. And my lord, after 3 years, suddenly it was, my lord, discontinued.
Well, I'm
We
not
were
on that.
Aware of that.
I'm only on this basis. They have discontinued, but the central government will be bound if they have not paid it to you. Because it is after all a central government scheme,
My lord.
of which 90 is theirs, 10 is
Yes,
yours.
10% off.
So however, it is between you and him. The petitioner cannot be bothered on how you get the finance, both of you. But you have to pay if the petitioner is entitled to.
My lord.
Now the question is whether the petitioner meets the criteria. This SLEC or the empowered committee has to look into it.
Lots of.
So that they have not looked into it wrongly, but they cannot say that we have not the scheme when they applied. They applied within the time. You pointed out some defect.
My lord.
So this defect they have immediately cured. And in that case of her, there is no defect. Unless you show me that once a person avails that remedy that he is not entitled to.
That, my lord.
That I'm not finding it anywhere.
My lord. No, upgradation and modernization itself, my lord, speaks. My lord, that it
Ah,
have to
there's
be
already
existing
there.
itself.
So, no, there might be a case also. There are many aspects. One, in certain schemes, it may be that you have already got the benefit under one plan. For upgradation, you are not
There will
entitled.
have to be a specific clause. to
But
it.
there has to be a specific clause
My
for
lord.
that. So the reason for which you have rejected it cannot be a possible
No, not
reason.
rejected, my lord. That is a ground cited in case of, my lord, my lord, Saikia's case.
Huh,
That
therefore,
is
you
the
have not
ground cited.
given her, na?
No, not given, not, my lord. In the meantime, my lord, the speaking order says, my lord, since it has been dealing now, we cannot on our own now continue because it was under
No,
process.
question of delinking. I'm only questioning. The central government may delink it. But this is between you and the central government. You have to take it up with the central government. The central government delinking, therefore they are there.
No,
Therefore,
no, my lord, now submission
I
has been
therefore took up that issue on
Yes.
that day
Yes.
and I have duly recorded in my order.
No,
If you
today
see-
also, my lord, the submission was made that if they are, my lord, eligible,
Ah.
provided they are eligible.
Now you see my order of 1111.
Yes, my lord, it's there.
This court made a specific query upon Mr. B. Chakraborty, the learned CGC appearing on behalf of the central government as to why no affidavit has been filed on behalf of the central government. It has been submitted that the respondent number 1 will make payment only upon completion of formalities by the state government. And as the state government is not satisfied with the application, the respondent number 1 has no liability to make payment.
Yes, but 3 and 4 para is clear.
So therefore, this I have already recorded it down.
Then, my lord, their liability automatically comes in.
The liability will there because
has
it
not
is
been-
their scheme. How they pay, therefore it is between you and them.
My lord.
How you take it up with them, that is another thing.
Lots of. One thing
And
they,
they've extended by the 2016 financial year, although it was suddenly stopped. The person who has applied all the ongoing projects or approved by the SMC, that will be paid up to 2016 financial.
that is the existing liability.
So,
Their
there is no
liability has not arisen because it has not been approved. We have stated in a speaking order that
That-
existing liability will be paid.
No, but Mr. Gogoi, I fail to understand how can it be said to be a liability?
No, no, not my lord. Supposingly, my lord, their scheme has been approved, their proposal has been accepted. And my lord, time to time it will be released. It's not that my lord, entire benefit will be given to them.
No,
in a very
there are
first form.
two.
Yes,
One is the first one pertains to first installment will be paid 50%.
yes.
And the remaining 50 is after the date of commercial production is over. So that is another aspect.
Yes.
But you have not given the first one.
No, no, that's why I'm saying, my lord, the existing liability, they want to mean that, my lord, those, my lord, where already, my lord, it has been approved. Here, my lord, in the midway, we have to, my lord, discontinue it because, my lord, of the dealing. That's our stand in the affidavit. Because correspondence were on. Nobody has said that. my
But
lord-
your liability was only 10.
Yeah, but, my lord, the 90%.
Unless the central government has given you the remaining 90,
My lord.
you cannot be made liable for 100.
Yes. No, not that part, my lord. That 10% liability upon the state was pursuant to the scheme. When the scheme has been discontinued, even that 10%, why we will pay, my lord?
You are bound because
no,
this
no,
is
I'm
your
not on
scheme
that.
on the basis of which they did it within that
That's why, my
period.
lord, no argument has been made on the point of, my lord, promissory estoppel.
There is a-
They should have made that point, my lord, that promissory estoppel, we have shifted the position, nothing, my lord.
No, they for in my court, they don't need to make that submission. Make it their submission.
I recognize that, my lord, that since, my lord, March 2014, they have never placed the case before the SLC. So where is the question of approving it? If we don't place before the meeting, you have.
Let me dictate then.
But
Lordship,
they have never placed.
With regard to item number two.
You have
Lordship,
no
there-
role.
No role, Lordship.
That I
Unwilling
know.
mistake of Lordship, improperly joined Lordship.
So we ask them once they get the money to pay you.
And in my lord, item number 2, the AIDC is a necessary party, my lord, who is there in the implementation of the scheme. They are not a party in the proceeding.
Where?
In item number 2,
There is Bina Bakers.
yes,
Who is the necessary party?
AIDC.
Why?
But they are there in the scheme, my lord. They used to verify and all, my lord. They are part of the scheme. In the first case, AIDC is there.
But it is being done by your state level committee, empowered committee only.
That's the
Ultimate-
department.
No, they are in.
Now, who is the disbursing authority?
It will be the industries department, my lord.
So it is the industry department, so unnecessary making them makes no sense. Chalo. Okay, while dictating, you help me in your facts. Heard Miss N. Saikia, the learned counsel appearing on behalf of the writ petitioner in WPC number 521/2024, and Miss N. Hawelia, the learned counsel who appears on behalf of the writ petitioner in WPC number 2811/2019. I've also heard Mr. B. Gogoi, the learned additional advocate general, who appears on behalf of the Industries and Commerce Department of the Government of Assam. Mr. So-and-so
Jinas, Lordship.
appears on behalf of NETFI, and Mr. B. Chakraborty and Mr. K. Gogoi, who appears for the central government in both the matters. What? I don't require it here now. The issue involved in both the writ petition pertains to denial of benefits to the petitioners under the under the scheme of National Mission on Food Processing, which was announced by the Government of India, Ministry of Food Processing Industries, to be implemented through the state of Assam. Taking into account that the petitioners herein allege that there has been deprivation of their entitlement under the National Mission on Food Processing scheme, it is relevant to take note of the salient features of the said scheme before embarking upon the facts involved in the present writ petitions.
One factual aspect may I clarify, madam. So far as the case of Mrs. Sekia is concerned, madam, there her proposal was rejected by OFS speaking order, which is under challenge in the item number 2. And in the item 1, my lord, they have prayed that, my lord, since, my lord, they have applied, they should be given the benefit. So there is a difference. Only that factual point.
Let me come to the facts, then I will inquire with both of you. Because her is the second round of litigation.
Second round of litigation, yes.
The Ministry of Food Processing Industries taking into account that the importance of agriculture as well as its allied products launched the National Mission on Food Processing bracket NMFFP during the 12th plan through state/union territory governments. Full stop. Initially, there was a set of guidelines issued by the Government of India Ministry of Food Processing Industries for the period from 2012-13, falling within the 12th plan. It may be relevant herein to observe, to take note of, that this National Mission on Food Processing is a centrally sponsored scheme which is required to be implemented through the state/union territories. The basic objective of the NMFP is decentralization of implementation of the ministry scheme, which will lead to substantial participation of the state government/UTs. The objectives of the said scheme, the NMFP, hereinafter referred to as a scheme, of the said scheme were manifold. Number one, to augment the capacity of food processor working to upscale their operations through capital infusion, technology transfer, skill upgradation, and hand-holding support. Roman 2. To support established self-help groups working in food processing sector to facilitate them to achieve SME status. Number 3. Capacity development and skill এই পেজ 28 তিতাবৰত চাই লিব হা 1 to 6 হলে 7 হলে এইকেইটা দি দিব Full stop. The funding pattern mentioned in the said scheme is in the ratio of 75 is to 25, that is, the government of India's share vis-a-vis the share of the states, except for the northeastern states, where the ratio would be 90 is to 110, and in the union territories, it would be 100% centrally sponsored. Taking into account that in both the writ petitions, steps were being taken, the writ petitioners therein had taken steps sometime after March 2013. Both, huh? Comma. It is relevant to take note of that the central government, that the Ministry of Food Processing issued another set of guidelines for the remainder period of the 12th plan, that is from 2013 to 2017. Both are food processing. You come under 101, page 101 of your, is this your guideline?
Yes, Your Lordship.
Now, you are for upgradation or what? Establishment. So it will come for establishment.
Establishment.
No, but this is the guideline, 101.
101 is Lordship, technology, upgradation, establishment, modernization, all the things are covered in that.
So you come under this only. এই যে আপোনাক যে মই কৈছিলো 1 to 7 বুলি কৰিবলে নহয় এটো 1 to 9 কৰিব এটো পেজ 91 পৰা আনি দিব অবজেক্টিভটো Clause 4 of the guidelines valid guidelines for the period from 2013-17 bracket hereinafter referred to as the relevant guidelines stipulates the structure of the state level The said clause being relevant is reproduced hereunder. Clause 5 next of the relevant guideline further stipulates the funding pattern of the National Mission for Food Processing, and a perusal thereof would show that insofar as the northeastern states are concerned, the said scheme would be implemented as a centrally sponsored scheme, and the payment would be made, and the scheme, and the central government would fund to the extent of 90%, and the state government's share is 10%. Clause 7 of the relevant scheme stipulates what are the schemes to be implemented under the mission during 2013-17. A perusal of the said clause reveals said clause, and more particularly clause 7.1.1, bracket Roman 1, that the scheme would be applicable for technology upgradation oblique establishment oblique modernization of food processing industries. Clause 8 of the relevant scheme stipulates that the scheme-wise allocation of funds and thereby empowering the state level empowered committee bracket SLEC to decide inter-se allocation of funds amongst the schemes mentioned in clause 7 of the relevant scheme. Clause 10 stipulates the procedure for approval. Taking into account the grievance of the petitioners in the present proceedings, this court finds it pertinent to reproduce clause 10 of the relevant scheme as hereinunder page 95. This court further finds it relevant to take note of another guideline which was specifically for implementation of the scheme of technology upgradation oblique establishment oblique modernization of food processing industries during the remainder of the 12th plan, that is bracket of the 12th plan bracket of 2013-17. In other words, the said guidelines related to the scheme as envisaged in clause 7.1.1 bracket Roman 1 of the relevant scheme. The objective behind the upgradation, behind the scheme for technology upgradation oblique establishment oblique modernization of food processing industries have been set out in clause 1. That is to increase the level of processing, reduction of wastage, value addition, enhance the income of farmers, as well as increase exports through thereby resulting in overall development of the food processing sector. It further stipulates the objectives further mention that the scheme was to extend financial assistance for establishment of new food processing units as well as technology upgradation and expansion of existing units in the country. This aspect is of importance as would be seen in the later stages of the instant judgment. Who would be the next? Who would be the eligible sectors? Now, which would be the eligible sectors have been mentioned in clause 2 of the guidelines. The eligible organizations have been mentioned in clause 3 of the guidelines. Which would include, amongst others, individuals engaged in establishment, upgradation, modernization of food processing units for financial assistance under the scheme. Clause 4 of the guidelines stipulates the pattern of assistance. This aspect assumes importance inasmuch as both the writ petitions is based upon the promise held out in these guidelines. It is stipulated in clause 4 that insofar as the northeastern states including Sikkim the financial assistance to be provided is 50% of the cost of plant and machinery and technical civil works, subject to a maximum of 100 lakhs. What are the eligible next? What are the eligible and ineligible components have been stipulated in clause 5 and more particularly clause 5.1 and 5.2. Clause 6 is of importance as it stipulates the aspect pertaining to receiving of applications. This clause 6 being relevant is reproduced herein under page 102. A perusal of the above quoted clause would show that the State Mission Director, with the approval of the SLEC, shall decide the modus operandi of receipt of applications directly or through banks, oblique financial institutions, oblique e-portal, etc. It further stipulates that in case the applicant does not propose to avail any term loan, proposals are compulsorily required to be appraised by any nationalized bank, oblique financial institution. And the SLEC would decide which are the financial institution who can appraise such projects. Next, clause 7 stipulates the procedure for submission of application oblique project proposal for financial assistance. It is stipulated therein. The said clause is of relevance and the same is reproduced herein under page 102. A perusal of the above quoted clause would show that the applicants seeking financial assistance are required to submit the application to the designated authority, oblique State Mission Directorate of National NMFP. And such applications are required to be submitted at least 2 months before the date of start of commercial production in the prescribed format, which is annexure Roman 3, along with the enclosures and documents. Clause 8 next stipulates as to how the payment, the grant would be released. Clause 8.1 stipulates that the first installment of the grant would be released after the firm had utilized 50% of the term loan, as well as 50% of the promoter's contribution, and on production of various documents as enlisted therein. In terms with clause 8.2, the second installment of the grant would be released only after confirming the commencement of commercial production through physical verification by the State Mission Directorate and submission of documents as enlisted therein. Next, what are the documents required? Have been mentioned in clause 9. In the backdrop of the above scheme discussed above, let this court now take note of the brief facts which led to the filing of both the writ petitions. First, WPC number 521/2024. The petitioner herein is a company registered under the provisions of the Companies Act 1956 and is engaged in the business, in the manufacture and sale of bread, biscuit, cake, cream bun, and varieties of biscuits and other items giving biscuits. Full stop. Yes, when did you start your business? Huh?
Expansion on the first one.
First part. Oh. The petitioner being encouraged by the scheme as well as the guidelines for implementation of the scheme of technology upgradation oblique establishment oblique modernization of the food processing industries during the remainder of the 12th plan bracket 2013-17
Earlier, 2008, 27.
intended to expand and modernize its existing unit accordingly. An application was filed on 26/3/2014 through the in the proper format. This application, along with the application, it is the case of the petitioner that all relevant documents as required in the guidelines were enclosed, including the Charter Accountant Certificate dated 25/3/2014. The said application was received by the General Manager, District Industries and Commerce Center, Kachar, on 29 and thereupon on 29/3/2014, the said application was submitted on 26/3/2015. And the general manager, District Industries and Commerce Center, Kachar, upon receipt of the application and finding that and opining that the unit had submitted all the required documents as per the guidelines, forwarded the application to the State Mission Director. Pusto. This forwarding letter dated 29/3/2014 is Annexure 5 to the writ petition. On account of the non-consideration, oblique delay in consideration of the application submitted by the petitioner approached this court by filing a writ petition, which was registered and numbered as WPC number 8249/2017. The respondents herein, including the state respondent, appeared in the state proceedings and took a stand that it had come to the notice of the authorities that the petitioner had already availed two other grants under the Ministry of Food Processing Industries against the same unit, and therefore another application seeking financial grant was not permissible under the NMFP scheme. In the same proceedings, the central government took a stand that as the scheme was withdrawn, the central government does not have any role to play in the matter. The learned coordinate bench of this court, by an judgment and order dated 16/8/2022, disposed of the writ petition. Opining that when the petitioner had approached by submitting an application it was incumbent upon the respondent authorities to consider the said application in accordance with law. And accordingly directed accordingly gave liberty to the petitioner to submit a detailed representation before the additional chief secretary to the government of Assam in charge of industries and commerce, ventilating its grievance in the matter. And if such representation is filed, the respondent authorities was directed to dispose of the same. Within a period of 6 months from the date of submission of the representation. The learned court bench also observed that if the departmental authorities were of the view that the application so submitted by the petitioner was a genuine one, and the same was complete in all respects, and was also submitted within the period of validity of the scheme in question, in that event, appropriate steps may be taken for redressal of the grievance of the petitioner, as may be permissible under law. And the petitioner was and the respondents were further directed to intimate the petitioner through a written communication. Paragraph number 12, 13, 14, and 15 of the said order, judgment on order passed by the learned coordinate bench being relevant, is reproduced hereinunder. Pursuant to the said judgment and order passed by the learned coordinate bench, the petitioner submitted a representation on 26/8/2022. The said representation thereupon was disposed of by the speaking order dated 15/12/2023. Thereby rejecting the application of the petitioner, rejecting the claim of the petitioner. And it is under such circumstances the petitioner being aggrieved has approached this court by filing the present petition. An affidavit in opposition has been filed by the respondents. Thereby, the respondents state, thereby supporting the impugned order dated 15/12/2023. The petitioner thereupon has submitted a reply, thereby enclosing the petitioner further, the petitioner had filed an affidavit in reply thereagainst. It is, however, interesting to take note of that the petitioner, by way of an additional affidavit brought on record, the stand of the respondent state in WPC number 8249/2017, which, as per the petitioner, was contrary to what stand was taken in the impugned order dated 15/12/2023. First. Let me come back. Now your turn is there. WPC number 2811/2019.
What done, my lord, that
The petitioner herein is a partnership firm registered under the Indian Partnership Act 1932. And is engaged in the business of manufacture and sale of
Rice and rice bran.
hmm,
Rice and rice bran.
rice and
Rice bran.
rice plant,
Bran, BRA.
rice brands. Being encouraged by the guidelines, encouraged by the scheme and the guidelines issued for the remainder of the 12th five-year plan for the period from 2013-14 to 2016-17.
Paragraph 7, I have established.
The petitioner proposed for construction of an industrial unit at a total cost of rupees 200.34 lakhs. When did you submit your wage application?
Okay, my submission was 24/7/2013.
Where is your application?
It is in the affidavit. The opposition submitted by them. Annexure A, page 9,
Page?
page 9. 24/7/2013.
There's no page 9 here.
Lordship, in the affidavit, in the affidavit filed by the state. Annexure A, page 9.
No, where's your application?
That's why we can notice 24.
Application is not in the format.
Lordship, the application form, Lordship, as per annexure 5. Lordship, those are enclosed in this.
Oh, it is not there. I'll help you. Application form as per annexure 5. The petitioner submitted an application on 24/7/2013. Along with various documents, including the application form in annexure 5. This application was filed directly to the Mission Director, Ministry of Food and Processing Industries, Guwahati. Upon receipt of the said application, the State Mission Director, National Mission on Food Processing, by the communication dated 5/8/2013, forwarded the same to the General Manager, District Industries and Commerce Center, Jorhat, for scrutinizing the application and submit the same to the State Mission Directorate on or before 31st of August 2013, so that the further necessary action can be taken by the Mission Directorate at an early date. The General Manager, District Industries and Commerce Center, submitted the proposal by the communication dated 23/6/2014. Wherein it was duly stated that the proposal for granting aid under the National Mission on Food Processing of the submitted by the petitioner was duly inquired and physically verified, and it was recommended that the eligible amount of granting aid to the petitioner's unit were as follows, where for technical civil work rupees 40,32,072, and for plant and machinery 1,19,66,091, and the total amount was rupees 159,98,163. It was further mentioned that the granting aid at 50% of on rupees 159,98,163 was rupees 79,99,082, It was also mentioned that a delay in forwarding of the proposal was due to late submission of the required documents by the unit as per the checklist. It was further to that, it was also stated that it was also mentioned that the unit had obtained EM Part 2, vide number 18171201402, dated 8/11/2013, and the date of commercial production was 20/10/2013. It is the case of the petitioner that thereupon the petitioner's application has not been considered.
Was considered by the SLSC committee, was
Huh?
considered by the SLSC
Ah.
committee.
The-
And it should-
It is the further case of the petitioner that the petitioner's application thereupon was considered by the SLEC in its meeting held on
7th May 2015,
7th May
2015, page 1.
2015, wherein it was mentioned that there was major difference between the bank appraisal and the CS certificate in regard to the investment of plant and machinery. Mission directed to obtain clarification from the unit as well as from the bank. Where is that? Bank's clarification?
Lordship, the bank clarified it, page. Gave us fresh appraisal report, which is at page, Lordship, 1 step. Lordship, 183 is the fresh one.
Huh?
183 is the fresh one. 183. This is 8, it's
What is the date?
8th May 2015. 7th May, Lordship, that meeting was held, 8th May they have given.
The petitioner on coming to learn about the decision in by the state level empowered committee on 7th of May 2015 obtained a certificate from the Canara Bank on 8/1/2015. Why did you obtain earlier? You were intimated on 25/5.
Lordship, Lordship,
Kindly come to 181. How did you know?
Lordship, the state level empowered committee, what is the decision, Lordship, we come to know, this is the formal receipt of the letter, but what is the decision like that we?
How did you know?
Lordship, the empowered committee decision, we come to know from that, but only the.
How?
Lordship, empowered meeting, Lordship, after the meeting, Lordship, the officers over there, we come to know that what is the decision of the meeting. It is the official letter which is there, otherwise we know about the meeting. This is the official letter which has been issued to me.
On page 192, my lord, they sought for a, my lord, RTI application
For certified copy of,
Yes, of the minutes.
certified copy, Lordship.
192.
The copy is not given to me. Only an intimation is given to me, thereafter I. ask
How
for-
did you get the intimation?
Lordship, this is the formal intimation, otherwise, Lordship, all the companies who are standing over there, they come to know about this from the people over there, that the state level power committee has already contained this meeting and your has been sent for clarification. Your has not been approved.
On coming to learn obtained a bank and thereupon intimated the managing director of the state mission directorate of the managing director of the state mission intimated the mission director, state mission director by the communication dated 8/6/2015. Whereby thereby enclosing the additional investment, thereby enclosing the certificate
Copy of
steps were taken by the respondent authorities. The petitioner sought for information under the Right to Information Act by the communication dated 20/10/2018. Communication dated 8/10/2018. What did you ask for?
Lordship, the copy of the minutes, that was the only thing they shared.
So why did you ask for minutes only?
No, because Lordship, without this, I cannot file a petition before the court. So we ask for a copy of the minutes of the meeting.
Sought for the copy of the minutes by the application filed under the Right to Information Act on 8th of October 2018, which was furnished to the petitioner on 15th of November 2018. Thereupon, the present writ petition was filed on
I didn't have to.
25/4/2019. The record reveals that this the date 6/2019 issued notice the respondents filed their affidavit in opposition. The state respondents filed their affidavit in opposition on 11/12/2019. Respondent number 4 had filed the affidavit in opposition on 11/12/2019.
Page 5, Lordship, of the affidavit, last Lordship, 7 8 lines, from the clarification. though the clarification. Page 5, Lordship. Though the clarification was submitted by the petitioner on 8/6/2015, subsequent to that, no state level committee could be held for sanction of granting aid under the scheme due to delinking of NMFP seen by the government of India in the Union Budget 2015-16. In this regard, the Ministry of Food Processing and Government has issued a letter to Chief.
Wherein it was mentioned that after the decision held on Seven 5/2015, the petitioner unit submitted a letter on 8/6/2015, which was received on 3/7/2015. But subsequent thereto, no state level committee could be held for sanction of granting aid under the scheme rupees 50 lakhs to rupees 100 lakhs due to delinking of the NMFP scheme by the Government of India in the Union Budget 2015-16. It was also mentioned that the Ministry of Food Processing had issued a letter dated 27/3/2015 to the Chief Secretary, Government of Assam, wherein it was clarified that no financial assistance for central government shall be available for implementation of the NMFP scheme by the state for the financial year 2015-16 onwards, in view of the delinking of the NMFP from financial support of the Government of India. It was also mentioned that the Planning and Development Department, Government of Assam, issued office memorandum dated 17/8/2015, mentioning about delinking of the union support for implementation of NMFP. Mr. Why do you say that there is no meeting held? Because in the other case, we see in the month of August.
No, my lord, the category is different, my lord.
No, category is same. This is above 50 lakhs.
It was, my lord, above 25 lakhs. So far as the petition, and second petition is concerned, my lord.
Kindly see that affidavit.
Yes, it's above 25 lakhs.
No, you have put.
In the affidavit, I am saying, my lord.
Now, where is that affidavit page here?
It is a page, my lord.
Earlier
81,
affidavit
82,
in that case?
81, my lord,
Uh,
down below.
page 80,
However, the application of the petitioner, last three lines,
80. Now, where is that?
page 81, the part of para 8.
Earlier petition.
Yes, my lord.
Ah.
Last fourth line, my lord. However, the application of the petitioner could not be placed in those meetings as the financial assistance sought was in the category of more than 25 lakhs. It is pertinent to mention here that the first meeting of the committee for sanction of financial assistance for rupees 25 lakhs to 50 lakhs.
So it was the category of more than
Held
25
of that.
lakhs.
So their category falls, my lord, above 50 lakhs. Petitioner number, in the second
So it
case.
was held on 19/8,
Yes, madam.
and for them there is no meeting. There's another affidavit file, na? This is
Yes,
one
madam.
affidavit.
There was one more affidavit that was brought into record by way of an additional affidavit.
Huh? No. Somebody filed an affidavit. You have not filed any affidavit.
In the first case, we have filed.
The second one?
Second one, my lord, only the affidavit which was filed in the earlier writ petition was brought into record by of an additional affidavit.
Earlier petition here, no, Titapur is for the first time.
It first, my lord, yes.
So here you have not filed any affidavit.
We have filed, my lord.
Huh? Are you sure?
Yes, my lord. That affidavit, my lord, it is filed by respondent number 4.
4 has filed.
Yes.
I'm saying about you.
The government has, otherwise, my lord.
Government has not
No.
filed. AIDC has filed.
Yeah, this year.
AIIDC. You have not filed any reply.
They cannot do anything.
In the backdrop of the above pleadings, in both the writ petitions, let this court now take note of the submissions so made by the learned counsels appearing on behalf of the parties. Mrs. N. Sekia, the learned counsel appearing on behalf of the petitioner in WPC number 521/2024 submitted that the petitioner pursuant to the scheme and the guidelines issued for the period from 2013 to 2017, took a decision to go for further additional expansion of modernization of its unit, and accordingly submitted an application on 26/3/2014, when the scheme was in operation. Referring to the communication issued by the General Manager, District Industries Center, District Industries and Commerce Center, who was the authority empowered to receive those applications. The learned counsel submitted that the said application categorically mentioned, the said forwarding letter categorically mentioned that the petitioner's application was duly verified and it was found complete in all respects. The learned counsel further submitted, along with the application, the petitioner has duly submitted the charter accountant's certificate dated 25/3/2013 or 14. Referring to the scheme as well as the guidelines, the learned Mrs. Saikia, the learned counsel for the petitioner, submitted that the benefit of financial assistance is not only given to new industries, but also industries who undertake technology upgradation as well as for modernization. There is not a single whisper in the scheme or even in the guidelines that if a industrial unit had availed benefits under earlier schemes of the central government for establishing its unit, the said industrial unit would not be entitled to benefits if additional additional expansion and modernization is carried out, being encouraged by the policy.
Still, my lord, base, whereby the measure director has said, my lord, that, whether receiving of such funds disqualifies it from availing of.
100 and
Commission. No, receiving of such funds does not disqualify the industrial unit from availing benefits under this scheme. 100 and last paragraph.
the Learned Council further, referring to Annexure B to the affidavit in reply filed by the petitioner, drew the attention of this court to the communication dated 17/3/2023 issued by the Managing Director of Assam Industrial Infrastructure Development Corporation, wherein it was duly mentioned that the petitioner had, by way of an affidavit dated 28/3/2014, duly stated that the petitioner unit had availed fund from the Government of India Ministry of Food Processing Industries of an amount of rupees 49.50 lakhs by sanction letter number FNO.7-10/2011 dated 7/25/4/2012 for setting up of its unit in the past. It was also mentioned that the present proposal was under upgradation program of the scheme. The Learned Council submits that though there is a mention in the said communication that how much upgradation was done could have been only known from the CA certificate. Which was submitted on 16/4/2015. But be that as it may, it is the submission of the Learned Council for the petitioner that the scheme that the petitioner applied only for additional assistance for upgradation oblique modernization of its unit. Anything else?
Last paragraph, my lord.
What is that?
Paragraph. Verification is given, receiving of such fund does not disqualify them.
It was also mentioned, and the Learned Council further submitted, that this very aspect is also mentioned in the communication dated 17/3/2023, wherein it was stated that the petitioner unit is eligible for availing benefits under the scheme under the technology upgradation oblique modernization for additional machineries installed for upgradation oblique modernization. Push. Nothing more. Miss N. Havelia, the learned counsel appearing on behalf of the. Why have you approached so late?
Lordship, before the court,
You?
Lordship, because I was apprehending that they will be doing the other.
Why were you sleeping? You were so proactive that even prior to your intimation, you got that certificate.
I was-
Then why you were sleeping till 2019? Why?
We were communicating because the.
No, there was no communication. There is not a single communication in your brief.
We were thinking that they will be setting up.
No, how many years? 1 year, 2 year, 3 years? You knew it very well that at that point of time in 2015, they have delinked.
We came to know.
Why haven't you approached this court then?
Even after delinking, Lordship, this is the state level empowered committee meeting were being held. So we were hoping that even for us also, some state level empowered committee may be held, because we were being assured that.
1 year is okay, 2 years is okay, 3 years is too much.
there were-
I think we should dismiss on that ground.
Lordship, because I did not have the copy of the Lordship, without the copy, we cannot approach.
Why did you apply in 2000? You knew everything. Why didn't you apply in 2015? Tell me, give me a good reason. Yes, Mr. Gowai,
My lord. Of course, my lord.
why are they not sleeping?
From my lord 2015 to 19.
Hmm?
2015 to 19,
80.
No, nothing was done.
except an RTI in 2018.
Yes, that is why I put that date. They made the RTI only in the month of October 2018
Yes.
and got it even in 2000 on 2011, 2018 and filed the writ petition on 25/4/2019.
On 15/11, the information was provided. 8/10/2018, my lord, they sought for the RTI.
Lordship,
That,
I had written that having no option, we were visiting the office several times and we were been assured that. they
Now,
have taken the
another
steps.
thing you tell me, anyways, I'll take it. Ms. N. Haveli, the learned counsel appearing on behalf of the petitioner in WPC number 2811/2019 submitted that the petitioner being encouraged by the scheme as well as the guidelines for the year 2013 to 2017 invested an amount to the tune of rupees 200 lakhs. Thereupon, on 24/7/2013, the application was filed seeking financial assistance in terms with the scheme and the guidelines. Pusto. The affidavit so filed by the respondent, number 4, also makes it very clear. Also 4, and more particularly, Annexure C would show that the General Manager, District Industries and Commerce Center may carried out various verifications and found out that the petitioner was entitled and forwarded the same to the State Mission Director with a recommendation that the petitioner was entitled to an amount of rupees 79,99,082. There was no mention therein that there was a discrepancy between the CS certificate as well as the bank appraisal report. On 7/5/2025, when the 15, when the state level empowered committee found that there were certain discrepancy and sought for clarification, the petitioner immediately obtained the certificate from the bank and forwarded the same on 8/6/2025. Immediately after having received the formal intimation from the mission director from the state mission director. Thereupon, the respondent authority, it was incumbent upon the respondent authorities, more particularly the state level empowered committee, to take note of the clarifications so submitted. And instead, on the ground that the central government would not be providing financial assistance for the year 2015-16 in respect to the scheme, the respondent authorities did not consider the application of the petitioner. Did not consider the clarification so submitted. The Learned Counsel further submitted that the petitioner's entitlement was on the basis of submission of the application in the year 2013, during which time the scheme was in operation and the petitioner having invested the said amount. The Learned Counsel further submitted that on the basis of the promise held out by the respondent authorities, more particularly the central government in its scheme as well as the guidelines, the petitioner made investment. And therefore, the respondent authorities on the equitable principle of the doctrine of promissory estoppel are liable to provide the benefits under the scheme as well as the guidelines to the petitioner. Anything more?
Now, I had made the statement that I had been communicating with them to hold the SLC meeting. They have not denied that statement in their affidavit in reply. Secondly, Lordship, nobody wants to come to the court that they always want that the department only should do the thing, that they should hold the SLC meeting. This is the last resort that we did. That is my submission. They have not denied it. Other paragraph they have denied. Only this paragraph they have not denied.
Yes. Mr. B. Chakraborty, what is your submission? No, we are concerned. I'm asking you a very specific question. These petitioners applied during the currency of when that scheme was in operation. You delinked later on. So you say that, okay, from 2015-16, we are not going to do anything. So kindly, we are delinking yourself. You want to go ahead, do a but from 2015, we are taking out from the scheme. But those people who have invested prior to 2015 and submitted application, can your delinking subsequently have an impact? Oh, it's a matter of right. You have, it is not a claim of grant. It is a case that you have given a promise, held out a promise that look here, if you do this, we'll do. It's not a policy decision. Hello, remaining, we give it again on. Okay, what are that is your submission. Your submission is this, na?
Well, that during the pendency of the my lord, applications, in the meantime, my lord, it was delinked. That's why. we could not
Dealing is
process it.
okay, but how do you take care of applications filed prior to that?
That, of course, is not the my lord, they have not raised any issue on that point regarding promissory estoppel and
Huh?
whatever is there in our, but in our my lord, letter of 2015, where my lord, it was discontinued by the state government also pursuant to the my lord, decision of the central government. There we have stated that, my lord, whatever pending liability is there, that will be, my lord, paid.
No,
But
this
my
is
lord, so far as the application.
whether you, whatever word you use,
Pending
this
liability
is
means, my lord,
a
where
claim. It is a liability is based upon a claim.
the liability will come only when it is recommended and, my lord, they are found to be eligible.
Then it is not a liability.
The
It
liability
is a
means, my lord,
grant which you are giving.
yes. But in the case, in these two cases, my lord, it has not been, my lord, finally not recommended. It was under the process. Some queries were raised in the meantime, my lord, this came, my lord. And on top of that, my lord, so far as the item number 2 is concerned, the documents which were submitted in April 2015 after the delinking by the central government, even then there are some, my lord, lacunas in those documents. Discrepancies were there. We have brought in record, my lord, in the additional affidavit that was filed in item number 2.
What are the discrepancies?
Lordship. Lordship will find it, my lord, at page 92, running
Page?
page 92.
90?
92 of WPC, my lord, 521 of 24.
92. Yes.
Para 6, my lord.
Ah. Without mentioning any date of signing, however, the same was notarized and
A, B,
signed
C,
on
and D, my lord.
16/5.
But finally, the reply is, my lord, that answering deponent basis to aforesaid documents clearly show that petitioner, though had submitted the application for grant in aid on 26/3/2014, the petitioner had submitted many of the required documents very lately, that is on 16/4/2015. Therefore, though the authorities of the answering deponent processed the application of the petitioner, the same could not be considered by that time. By that time, the Ministry of So and so, my lord, discontinued. But that's not in the form of an affidavit. ma'am. No, the surety bond is dated 16/4/15. Page 99, my lord. This is a surety bond, part of the surety bond. And, my lord, so far as the CS certificate is at page 100.
Madam,
This-
tell me, this is the surety bond you submitted, na?
There's no denial to the.
This advancement, everything. This advancement.
Is this the surety bond you submitted? What is the date? You produced the records. Have you got the records?
My lord, records, my lord, could not be placed, my lord.
You said
I
that
wrote-
you
no,
are
no, I wrote a letter, my lord. They requested the AIDC, my lord, to furnish it, but it has not been furnished, my lord. I got a communication.
Where's the date?
Petition number is there, my lord.
What is the date?
Not sorry.
Isn't it required to be filled up, that surety bond?
Nothing is there, my lord. Page 99.
Yeah, my lord. Date is not there. But
The page-
the advance was given, my lord. On my lord, because receipt is there, FM has receipt. Uttar Pradesh, 26,
Huh?
26/3/2014 receipt is there.
What is the date of this surety bond?
Say last page, my lord.
After its will is there.
Last page, my lord.
The photocopy it is not eligible. Date is not reflected, eligible. Maybe in the original records it is.
This is your original record.
And it's the photocopy. of-
This is what the photo, you had a photocopy of everything. There's no date of this surety bond. Chalo, we'll have it next Thursday again.
My lord.
In the meantime,
I
get
will
the
try
hold of
to
the
do-
records.
yes, my lord.
The records which have been sought for have not been produced. Gustav, it is necessary for the purpose of adjudication of the instant proceedings that the records are produced. More particularly, the application which have been filed by the petitioner in both the writ petitioners in both the writ petition. List this matter again on 27th of November 2025 at 10:30 AM for further consideration. In the meantime, madam, you bring this by way of an affidavit. This one.
My lord, date.
This is not good.
Date and-
But you make your submissions on delay.
Not sir.
Make your submissions on delay because these are questions here.
Financial implication. my lord.
And when you are asking for benefits,
My lord.
they
There-
have to come. Just for example, if the appraisal report has not been submitted properly,
Lot, sir.
so can it be deemed to be an application at all? If that, because clause 9 categorically says these are the things.
To be submitted.
So they're further giving the certificate on 8/5, on 20, or whatever may be by them. Wouldn't that amount to a fresh certificate being submitted?
My lord.
Now, that is one aspect. But most important aspect is, whatever may be, they invested, they filed the application.
Yes.
The general manager said it is okay. In this case also, the general manager looked into many things, and in 2014 itself says that they have submitted all the documents and we have found it okay.
My lord.
So it is only a clarification sought for as to why there was a discrepancy, and this discrepancy has been clarified.
Lot, sir.
So under such circumstances, can you therefore say, because it is 2015-16, after that you may have stopped,
Yes.
you have delinked it. But these are these are things, claims prior to 2015-16. So can you therefore say that those who have invested, it is gone? Because they have been continuing. Only thing is, I have problem with Ms. N. Havelias who approaching after 4 years. Because this is very important.
The amounts to waiving of the right, my lord.
Huh?
Waiving of the right.
Waiving of the right, they slept over it and now they are coming. So that is the only issue.
My lord.
You find out some judgments to your benefit on the next date. If you don't find, matter goes.
I will place them.
This is my prima facie opinion. I have not finalized. I'll finalize when I'm dictating.
Lot.
Yes, any urgent matter for anybody? Because I don't think I'm sitting in the second half. I have a division bench. Onto,
My lord, report has been submitted.
this order was passed on 2310, a bit lately uploaded. So I think we should ask the what you call the trial courts to have a look at this order
Yes,
and thereupon to do the needful.
my lord. My lord. May I point out one thing, my lord?
Right.
Or is my lord, Annexure A, very first page, my lord. The warrant of, non-bailable warrant was issued on 5/6/2025. But what happened thereafter? Because
No,
is case
Here-
is 60 there,
no, here this
I've
order has
seen-
been passed.
my lord,
What is required to be done has been explained.
my lord.
So it is required to either close those which is possible in
Right.
view of section 256 and
56 and
249 of the
250,
CRPC.
214.
This is one. Secondly, a recent judgment has come from the Supreme Court. You must be aware of that.
Yes.
Wherein now it has been directed that once the trial starts, it has to be taken on a day-to-day basis. And it cannot be just, for example, half you are doing a witness today and that witness will be done on another day. It can't happen like that. So it has to be done that day and then completed on that day or the next day itself. These are specific directions being passed by the Supreme Court.
My lord.
And have also asked the High Court to issue necessary circulars in that regard. You must be aware of that,
My lord, no, my lord. So,
of Justice Padiwal. huh?
the
Justice-
Aswani Kumar Upadhyay, my lord.
Huh?
The same case.
They have- you cannot take it.
No, very recent judgment. I think 10 days back,
My lord, I'll go through it. now.
10, 15 days back.
Then
So
the
this is,
Supreme
I
Court-
think, idea. nahi. Any report given today? He doesn't to put in. Let me see. Did he get the he bureau again to the bench?
Vice CBI versus Mir Usman. 20. Because 11 parameters.
Pending get our equivalent to the assembly taken in every complaint is not taking steps although under a KG.
Para 37.
Time
CBI versus Mir Usman.
Hey, judgment book ko lang. Cannot be.
Umir Usman.
Usman side. Administrative order pass over. CBI versus Mir Usman. Para 37. It was my lord, CBI versus
Mir Usman.
Mir Usman. Para 37 details, my lord.
Of which judgment? This is particular.
Yes, but particular version Vishwanatham, yes.
This recent.
37 details is there.
What is the name?
CBI, Central Bureau of Investigation versus Mir Usman, alias Ara.
ARA, no?
Here. That is decided on 22/9/2025.
Central?
Bureau of
CBI
Investigation.
versus
Central Board.
Bureau, CBI. Sorry, sure.
What is the citation?
Pilot,
Citation?
citation, yes, CC online.
No, it is seen from the live laws, man.
I don't know.
Mir Usman, MIR.
Can you ask him to give it to me?
Yes,
He do share to
SCC is there.
online to learn.
Just give me the name.
2025 SCC online, Supreme Court 2066.
SC 2066.
2025,
2025 SCC online, SC 2066.
2066.
2066.
Oh, yeah.
Yes, which paragraph?
Para 37.
Online of online of बेलेग हो ठीक है 37 ना
Necessity for the High Court to issue circular. The heading.
Para 35.
Yes, para 35, in 37, my lord. Direction to the High Court to issue circular.
That is okay, read para 35.
Yes, ma'am.
Para 20. Read para 20. Twenty and 21 is the question.
20. 30.
Yes. So that means the director of prosecution also hears it.
Yes.
Well,
Well, so, I shall read it.
No, you read it
Yes.
unless something is.
309 of the CRPC, now section 346 of BNSS 2023, containing a mandatory provision that every inquiry or trial, the proceeding shall be held expeditiously as possible. But in the particular, when the examination of the witness has been once begun, then the same shall be continued for day-to-day basis until all the witness in the attendance have been examined, unless the court find that the adjournment of the case beyond the following day be necessary for the reason to be recorded. The emphasis of this action cannot be overlooked and must not be overlooked by the judicial officer who tried a criminal case, much less by the higher officer, like the session judge proceeding over the session court where the serious offense are being tried by day out. 21. And it is true that the court has been discretion to defer a cross-examination, but that do not approve the party practice prevailing in the trial court across the country, that the examination in chief of the particular witness is recorded in a particular month. His cross-examination would be followed in a particular subsequent month. Legal position is that once the examination of the witness started, court concerned must continue the trial from day to day until the witness the attendance has been examined, except those whose public prosecutor has given up. We are at the pain to note that it is almost a common practice and regular concern that the trial courts float out the said mandate with impunity. Even if the witnesses are present, cases are adjourned on for far less serious reason or even a flimsy ground, the legislature itself had found and the granting adjournment on a flimsy ground.
Before that, there is another paragraph.
Yes. That is good. I think maybe you go.
You want to?
35.
Now kindly come to this particular thing, paragraph 13.
30.
Here they are referring to this judgment of Sambhunath Singh. And kindly come to paragraph 13 and 14.
13 and 15.
Yes, Mr. Fukan, you read it. We may
Paragraph
not
13.
trouble the senior counsel.
Paragraph 13, my lord.
Yes.
In a comprehensive decisions of the court,
No. Now we are distressed. Paragraph 13, they have quoted Sambhunath Singh. Now kindly come to paragraph 13 of Sambhunath Singh. It is there, the next page.
Sambhunath Singh's, my lord.
13 of Sambhunath, not of this. Main paragraph starts at 13. Now you go 11, 12,
Fine.
13.
Yes. The 11, my lord, the
No, you go come to 13.
13.
No,
Oh, yes, my
now-
lord. Inner number.
Ah.
Yes.
Now,
Okay, now we are distressed to note that it is almost a common practice and regular occurrence that the trial courts flout the said command with impunity. Even when witnesses are present, cases are adjourned on far less serious reasons or even on a flippant grounds. Adjournments are granted even in such a situations on the mayor asking for it. Quite often such adjournments are granted to suit the convenience of the advocate concerned. We make it clear that the legislature has frowned at granting adjournments on that grounds. At any rate, inconvenience of an advocate is not a special reason for bypassing the mandate of the section 309 of the code. And 14, if any courts find that the day-to-day examinations of witnesses mandated by the legislatures cannot be complied with the due to non-cooperations of the accused or his counsels, the court can adopt any of the measures indicated in the subsection, that is remanding the accused to custody or imposing cost on the party who wants such adjournments.
You see, remanding the accused to custody.
My lord,
Yes.
remanding the accused to custody or for imposing cost on the party who wants to such adjournments. The cost must be commiserated with the loss suffered by the witnesses, including the expenses to attend the court. Another option is when the accused is absent and the witnesses is present to the examine, the court can cancel his bail. If he is on bail, bracket, unless an application is made on his behalf seeking permissions from his counsel to proceed to examine the witness's presence, even in his absence, provided the accused gives an undertaking in writing that he would not dispute his identity as the particular accused in the case. And
Now for Mr. Fukan,
My lord.
kindly read paragraph 28.
20, my lord.
28.
28. It is in the light of the settled legal positions that it is no longer possible to question the legitimacy of the rights of to speedy trial as a part of the right to life under Article 21 of the Constitutions. The essence of Article 21 of the Constitutions lies not only in ensuring that no citizen is deprived of his life or personal liberty except according to procedure established by law, but also that such procedure ensure both fairness and expeditious conclusions of the trial. That is the fundamental rights of the persons. Article 21 should not be violated.
And paragraph 36,
Paragraph 36, one of the significant factors contributing to delays in the justice system is the discretionary practice of the non-continuous criminals trial, where evidence is heard by the court in piecemeal fashions, with cases effectively spread out over the course of many months or even a year. While limited judicial or court resource and a shortage of available court time due to the volume of cases are often cited for the use of this discretionary practice, the cost of non-continuous trial to both parties and to the justice system as a whole can outweigh the perceived benefits.
and 37.4, what is the circular to be issued by the High Court?
My lord. 37.4 is the court should not grant the adjournment to suit the convenience of the advocate concerned except on very exceptional grounds like bereavement in the family and the similar exceptional reasons duly are supported by memo. Be it noted that the said inconvenience of an advocate is not a special reason for the purpose of bypassing the immunity of section 309 of the CRPC.
Now, what happens when the court is not, the council is not cooperating? Number 5.
Yes.
In case of non-cooperation.
In case of the non-cooperations of the accused or his counsels, the following shall be kept in mind. A. In case of non-cooperations of the counsels, the court shall satisfy itself whether the non-cooperation is in inactive collusion with the accused to delay the trial. If it is so, satisfy for the reasons to be recorded in writing. It may, if the accused is on bail, put the accused on notice to show cause why the bail cannot be cancelled. B. In case where the accused is not in a collusion with the lawyer and it is the lawyer who is not cooperating with the trial, the court may, for the reasons to be recorded, appoint an amicus curiae for the accused and fix a date for proceeding with a cross-examinations and trial. C. The court may also appropriate cases impose cost on the accused commensurate with the loss of suffered by the witnesses, including the expenses to attend the court. D. In case when the accused is absent and the witnesses is present for examinations, in that case, the court can cancel the bail of the accused if he is on bail, unless an application is made on his behalf to seeking permission for his counsel to proceed to examine the witnesses present, even his absence, provided the accused gives an undertaking in writing that he would not dispute his identity as a particular accused in the case.
So now we see these. The presiding officer of every court may evolve the system for framing a schedule of constructive working days for examination on each day and well in advance after ascertaining the convenience of the counsel on both sides. Summon procedure would be handed over to the public prosecutor in charge of the case to cause them to be served on the witness as per the schedule fixed.
By request.
Now, Mr. Phukan, on account of you being not in a position to provide witnesses, the delay, that is why I asked you to read that paragraph 28.
My lord.
It violates the mandate of Article 21 So that is it. So you cannot on your own say that my witness, I'm not getting out there and as such. So it has to be closed down somehow.
My lord.
As regards the witness, now, if you see the today's this particular thing, the annexure which has been provided, Mr. Mohanto, have you looked into this?
Yes.
And you give it to him. You also have
My lord,
this.
the deputy, my lord, DCP is, my lord, the deputy.
No, this is being given by the registry.
Oh, yes, yes, my lord, yes, I have got it,
Percent
my lord, yes. it will-
Now, this particular document, if you see,
My lord,
on very silly reasons, the matter, the trials are just being, there, he is not taking up the trial courts are not proceeding.
my lord,
This is not what is conceived of in our order which we have passed earlier, as well as what is now the directions of the Supreme Court. Although it has been laid down, now the Supreme Court has been more categorical and they say for every matter.
my lord,
We are concerned out here as regards MP, MLA matters where there is more urgency.
my,
As you could see in paragraph number 35 of the judgment wherein it says all in respect to sensitive matters. Now we fail to understand why non-bailable warrants of arrest have been issued, but police is not taking anything.
Today is the date, what happened, 2011, both cases now.
Nagaon. Why non-bailable warrant of
2008.
arrest
my lord,
have not been executed against the person whom I think the Nagaon police must be knowing where he is. We would need not mention the name of the accused, but it is apparent everybody knows where he stays.
my lord,
And he is not in a position to move around also so much. That is one. Nothing has been done. So if the police is not doing anything, why not these ABCD, 5 ABCD should not be followed? In the case where a person concerned who is on bail and he does not appear, so
my
the
lord,
bail be cancelled.
my lord, yes.
And his lawyer is here.
His lawyer is there.
Hmm.
So on the basis of his lawyer's presentation, the court has to proceed.
My lord. If
And
this-
as regards your cases also, you cannot delay that, okay, some witness will come someday or not. The witnesses are not coming. Now, in view of this mandate now, which is being given by the Supreme Court in these paragraph, you have one witness, that witness has to be examined and finished off. And it can be further taken on the next day at best. It cannot be, okay, partly we have his chief being recorded and tomorrow cross
Yes,
after
sir.
1 month.
1
The
month.
concept is absolutely foreign now.
My lord,
So therefore, I think we should give the trial court due notice about our order, which we have passed
my
earlier,
lord, yes,
as well as applying the law which has been laid down by
By
the
the-
Supreme Court in this
my
judgment,
lord.
and thereupon ask for a report after 1 month. What report they have given the trial court is
Not-
far from being
Even if you
satisfactory.
Kindly see here in this case, my lord, notice of the non-bailable bail warrant was issued on 5/6/2020, thereafter not returned. What do you mean by not returned?
It cannot happen like that.
My lord, in this regard, my lord, I have many times communicated the SSP Nagaon as well as the DCP East. My lord, they have furnished a report, my lord, kindly see. There, both the reports are contradictions, my lord. I have annexed in this, my lord, no, more different.
That night.
No, এটা বেলেগকে আনিছো।
There is two matters out there. We have this,
My lord,
No, no,
there
that
are
is-
two
that is-
matters
that
which
is
I
their
could see
internal-
out here.
That is their internet.
our internal reports, your lordship, এখনো দিছো।
The second paragraph is good.
And the copies are annexed in the last pages, my lord. Their reports are
Nagaon
annexed,
said he sent, he Guwahati says we have not received. Very good.
yes.
And are we to understand that these, one person concerned, there are two matters, just for example, these two matters. At serial number 6 and 7.
Kamrup.
Yes.
Visit Kamrup Metro.
6 and 7, my lord, we have verified.
Yeah, yeah. It's when he is one. it is two, seven. Yeah, well,
Complaint is not taking steps. Although the other opinion is approved.
Six and seven.
Pension since 2024. Six, seven.
6 and 7.
6, 7.
First of all, if there is a non-bailable warrant of arrest has been issued,
On 24th.
something has to be done.
6 and 7.
And it is unbelievable that this particular person can't be found.
He's just sitting.
You may just wait outside Dispur, you may find him. Secondly, another
Same
person,
person, same person.
this.
6, 7, same person.
Seven. But my lord, I have little bit doubt in item CL number 7, my lord. Here the parties is Radhika Express Service versus BD Bone Warehouse, my lord.
Maybe, but he is a director.
Person
of
is wrong.
whatsoever, he is ultimately you are dealing with an MP.
My lord,
MLA.
MLA, that's
Fine.
why
He's
he's
an
doing
APM.
it today.
my lord.
If he is a manager of that bond, there is nothing to do, my lord.
Here, my lord, the last order I have received from the court, my lord, CL number 7.
We have 4,
Yes.
5, 4, 6, 5. 4, 6, 5, you see, yes. Very case. And yeah, and I case. Yeah, 4, 6, 4, 6, 5, 1, 4, 6, 5, 2.
465.
Why are adjournments like these are being given? They can't give on adjournments taking into account the law.
My lord.
So we therefore, I think for the time, we have it after 1 month, this matter. Ask them, because the report which have been given by these officers is not satisfactory. Ask them in view of our order, as well as taking into account the decision of the Supreme Court in so and so, Iman. And we ask the registry to circulate these orders to all the district courts.
Already that direction is there in the Seraton.
This our order,
Yes,
as well as the order passed by the Supreme Court to all the district courts,
Fine.
so that due action can be taken
Fine.
and a report be submitted. And this is not only for the purpose of these matters which are there, but in respect to all other matters also. Yes, registry. Is there any circular issued on the basis of this? Because the Supreme Court has directed the High Court to issue a circular. Where is the registered judicial? Please call him.
The director administrative side to issue circular with respect to district judiciary.
Yes.
Where that circular is issued. If issued, we'll ask them, will not go to the judgment, simply say that they will.
And also direct, my lord. And also direct, my lord, that two provisions, my lord, the 240 and 256 may also comply with, my lord.
Now, therefore, we say that the report which have been called for and produced before us is not satisfactory. We request these trial court judges before whom these matters are there, and more particularly the details which have been mentioned in that particular order,
My lord.
to look into it, and also keeping in mind the directions passed by the Supreme Court in this.
My lord.
And we ask the registry to forward a copy of that order along with a copy of this order to these officers, so that they can do the needful and report before us on the
Along with
next.
today's order.
Huh?
Along with today's order.
Vote which order?
Ha, ha.
Today.
Our order, this or today's order may not be, but 2310.
My lord.
Mr. T.J. Mohanto, the learned counsel, senior counsel, assisted by so-and-so, appearing on behalf of the Guwahati High Court. Mr. M. Phukon, Director of Prosecution. Mr. D. Mojumdar, the learned senior counsel, appearing on behalf of the state of Assam. And Mr. R.K. Dev Chaudhary, the learned DYSGI. Pursuant to our order passed on 23/10/2025, a report has been placed before us by the registry as to what steps have been taken by the concerned courts, trial courts. And more particularly in respect to those matters which have very specific reference have been made in the order dated 23/10/2025. We are of the opinion that the said steps, the report, as well as the actions which have been taken by the learned trial courts do not appear to be satisfactory, as well as in conformity with the settled principles of law. Full. In this regard, we ask the registry of this court to apprise the learned trial courts before whom the matter, the various proceedings are pending, the details of which have been mentioned in the order dated 23/10/2025. The judgment of the Supreme Court in the case of Central Bureau of Investigation versus Mir Usman alias Ara alias Mir Usman Ali, reported in 2025 SCC Online SC 2066. Full stop. A copy of the said judgment in the case of Mir Usman Supra be also forwarded to the concerned judicial officers, concerned trial courts. Full stop. We would seek a report on the progress from the learned trial courts on on 7th of January, on 8th of January 2026.
My lord, may I pray, my lord? Last occasion, my lord, there is directions to, my lord, the Director of Prosecution to furnish a report and in this regard, a next date fix, and which shall be included details, roadmaps. My lord, I have furnished the, that may be recorded, my lord. In paragraph 16, my lord,
We-
last order.
We would also find it relevant to observe that pursuant to our order passed by this court on 23/10/2025, the Director of Prosecution have placed before this court a roadmap, a detailed roadmap. Full stop. The same is kept on record and marked with the letter X. Full stop. We shall consider the same on the next date.
Much obliged, Your Worship.
Yes. What have you done as regards the circular?
I can remember lot. We have circulated it along with the circular.
No. Where is the circular?
Yes, we will produce it shortly.
Have you issued the circular or
As
not?
far as I remember. Lord.
You're, we go as per hearsay.
We'll go by record.
We go by records.
Give us the copy.
Give me a moment, Lord.
Anyways, you circulate this judgment amongst those trial court judges. We have passed that order.
And keep a copy in the record. You're not able to. Circular.
Much obliged, Your Worship.
Mr. Advocate General, we'll hear you first. Any progress?
Yes, there is progress. I mentioned to your lordship last time there was a pen down strike or something for 1 month. That's all over. And we have seen the drawings given by the concerned contractor. Pursuant to that, we have referred it to our own engineer to look into it. We are going to get the feedback from them. Because I think according to that, the Honorable Chief Justice's court and 4 other courts they wanted to furnish. We are looking into it, how much we can minimize the expenditure. Because there's a little bit of crunch as far as the finances are concerned, your lordship is aware of that. So once he verifies, the chief engineer verifies it and he gives us the report, then we will proceed in the matter. It's a positive development. We don't have to do anything. As soon as the report comes,
Just-
we'll.
Yes.
Yes. So as far as that issue is concerned, you can treat it as that almost in good compliance, in good spirits. So once we get that, it will be taken care of.
So, till date, no work orders have been issued on
No,
in
my lord,
respect to the furnishing.
in fact, here, we got the details from the contractor. The contractor would like to have as much contract as possible. That's one part. So we have to balance it with our actual requirements and also our finances. So that is why we had specifically told them that you verify, the chief engineer, what exactly are our requirements, and then accordingly we will proceed. So that is in progress. Even today, I got the intimation from the
Have
law.
you been a meeting with I think there is a committee also.
Yes, please, madam.
Made by the Chief Justice,
Please, madam.
who is specifically in charge, with a judge out there who is
Please, please.
specifically in charge of Nagaland. Who is presently, I don't know. This register PMB. Is there a committee constituted for Nagaland? Because earlier, Justice Jamir was there along with various officials from the government of Nagaland. Now, after Justice Jamir had left, have you constituted another committee by the Chief Justice? Just for example, for the state of Arunachal Pradesh, you have Justice Kardak and the officials of the government. I think for Justice, for Mizoram, I think Justice Yothankumar is there. So who is there for Nagaland after, have that committee been reconstituted? Because why I am saying, Mr. Advocate General, the
Wait,
reason why I'm saying is this. What would be the necessity? Not only the chief engineer can say, it is also the High Court has to be taken note of. What are the chairs required, how the
That's
quality
right.
of the chairs has to be, and all these things has to be looked into. Now, as we could see earlier, when we went out there, it is the lot of things have to be done as regards the furnishing. That from the table to everything. So, including the bar has also to be consulted as regards the table. How much you do, that is your prerogative as regards the bar. But otherwise, the concerned, the judicial, the judge who is also heading a particular committee has also to be consulted. So that is the reason why I'm saying that how it is to be managed. Therefore, I was asking, because right from the time of our Chief Justice Mehta, there has been specific committee for statewide. Although we have a building committee overall, but the statewide there is a committee. So that committee where you have the chief engineer as well as the commissioner and secretary law and justice is also there, who is there. So this- Huh? Yes, I think the advocate general is also there in that committee. So have you made that committee? Or has it been there? Okay. So now he's been given for Kohima. Portfolio. Ah, so we already have. Ticket of deal, page 41. At serial number 41. So this is the committee which is looking into that. So what is happening, how the furnishing or what is required? This is, I think the engineer in chief is there. I think President Bar Association, you are there, the secretary judicial department, as well as 2 judges are there. So there has to be some. meeting
Now,
of mind.
actually, you know, we are in the final lap of the relay race. The last man has taken the baton. So I think after I got written communications also even today from the laws. I insisted on that to actually know what is happening on the ground. So I think we'll pursue the matter, and once they verify everything, we want a proper verification because I mentioned to your lordships that the contractor would like to have a large contract,
Yes.
which may not be in our interest.
Our view is that there should not be wastage of.
Correct. Correct.
Your concern we appreciate.
Very.
But at the same time, we also, that in the name of cost cutting, it should not be such that this is not acceptable.
No, no, not at all.
So therefore, the what we propose is that consultation with this committee where you are also present. You go ahead with this, but I think this will help both side, all the sides.
Yes, just by way of caution, we wanted a verification to be done because our experience in the initial stages when we started, some things went hayway in which the government landed in some type of complication.
That is why you are.
Now,
you
at
are
the
there in
final
the
stage,
committee.
we want to be extra careful. So we insisted that you verify what exactly you want, what are the things, let everything be very transparent. So once that is done, I think that, as I said, this will be the last lap. Then other things will, in the next month, we'll also have some meeting on these points in Kohima itself. Maybe your lordship will also be there. Then we'll work it out.
I am not there. My brother would be there and the chief justice would be there. But Mr. Advocate General, while we are taking up this matter, another issue is that in the other writ petition, where an affidavit has been now filed by the government, whereby it is seen that as regards 4 posts of court master, 4 posts of court master and 3 other posts and another 7 posts have now been placed before the cabinet. Initially, it was placed before the cabinet. The cabinet sought for a justification. Again, another justification has been given. The finance has already approved, but the cabinet has to approve for the
I will look
creation of
into
these
that.
14 posts.
We'll
I will
definitely look into
that
it.
aspect.
There won't be.
Yes.
there-
So once that is done, so
That will be done.
yeah,
We'll look
because it's really surprising when I was there that you in Kohima bench, although we have done 50 years, we don't have a court master. So these are the 4 court masters, of which
definitely.
for the chief's court there will be 2, and for the other 2 judges, one court master.
That
So
will be
that
done.
is what it is. So
Give it
then,
priority and we'll look into it.
then we will take it as your submission that you are further progresses have been made and certain verifications are being carried out, and pursuant to this verification, necessary
We'll do that.
the needful will be done.
Very well.
Is what you have submitted.
That's right.
Okay. Then we'll put it this way.
Very well.
And as regard the other writ petition, we request you to kindly expedite
We'll
the
do
matter
that.
with the cabinet.
We'll do it.
Yes.
That's no issue.
Let us now take up the various other aspects pertaining to
With
toilets.
your lordship's permission, could I take leave, my lord?
Huh?
Could I take leave from your lordships? I was supposed to go in the evening at
No, no,
4:45.
Mr. Advocate General, we have already
Yeah,
heard.
I'm
you.
very
We'll
grateful.
record
I'm
your
very
submissions.
grateful.
Because this will take some other time because
Very-
there are other various other issues in
Very
various
good.
other.
I'm
Mr.
grateful.
Please.
Grateful.
Lordships has expressed your mind, Lordship, with regard to the other writ petition. I believe that will cover up 163.
Yes, yes. So that is what Mr. Jamil, we have therefore requested the Advocate General to take it up with the cabinet so that on a early date it is being done. So we
Yes.
keep this writ petition pending and taking into account the affidavit which has been filed by the government now. We
Okay.
look into it because the government have already, the finance has approved, as well as now the PNR AR has also approved. So now the matter has to go to the first time, now justification has been given to the cabinet, and the cabinet would look into it. And the learned Advocate General has also assured us that something good will happen.
Lordship, only one anxiety is the moment we shifted to the new complex, then more additional forces may be required. And
Mr. Jamil,
been
we will do
forced.
that. I'm not closing your petition now. Don't worry,
We
we are
we
not
have
closing our
confidence in Lordship,
petition.
that Lordship will definitely
will
be
only expect these 4 court masters and all these things
Lordships.
by on the reopening as a Christmas gift to the Nakuhima bench.
Since the learned Advocate General is also there,
Yes.
hopefully he will expedite the matter, Lordships.
Yes, yes, that is what he has given us. He said that he's looking into it.
Highly obliged, Lordships.
Okay. So it has been removed now. So you have no problem with
No,
that.
the status report is there, but
Ah.
Lordship will find the details in the minutes manner. There is a flag mark it manner. There is a minute of meeting. Dated 18/11/25. There it is very elaborately given. Manner.
What is the status report?
8 projects have been completed. Work in progress is something 12. Tender, process of tender is going on in about 8 projects.
So nothing much has progressed as regards the accommodation of the lawyers.
My lord, that is there, my lord.
You are looking into the BSNL and the Meghdud Bhavan.
There are 2 options, my lord. Either to construct the my lord building in
No,
the campus or to shift. Yes, either way, my lord, whichever my lord is the most feasible one, my lord, we will proceed.
And we have today requested some of the district judges today to be present. Uh, can you tell us, who are there from which place? Okay, District Judge Tinsukia. I could see somewhere, Tinsukia.
Yes, Lordships.
Yes,
We
what is the
visited
present
a-
situation of construction of the toilets there?
Yeah, in Tinsukia, 25% has already been done. Foundation has already been, it will be completed within 2-3 days. And in Margherita, construction has been started from.
Madam, can you bit louder? We have
Okay,
difficulty
Lordship.
in hearing.
Okay, Lordship.
Yes,
Am I audible now?
yes, now audible.
Yes, Lordship. In Tinsukia, 25% work has been done till date, and the foundation will be completed within 2-3 days.
Vinsukia is status report.
8, 9 and
8, 9, 10, ma'am.
Serial number?
8, 9 and 10.
8, 9, and 10. LOA has been a work order issued, work is in progress, 20% is done. One, Margareta, only 5% progress. And number 10, Hodia, mobilization of work, nothing has happened. So only 20% has been done in Tinsukia.
Yes, Lordship.
And what about anybody from Dima Hasau here? Nobody. Hunitpur? Nobody from Hunitpur?
All are not all, I think,
Work is in progress, physical progress is 21%. Okay. Yes, now coming to Hunitpur, Mr. Bigoway, what has happened? We are having a problem which I think necessary proposals now would be submitted to the government also. I'm taking up the matter while going there on this 29th out there. You see, the CGM establishment is standing on a heritage building. You can't even put a nail out there. But it is built out of Ereka wall. So you can't do any construction, no renovation, nothing. But it is in a very dilapidated situation. There are two aspects which requires. One is we are considering to have another building for the CGM because this you can't do anything with that. And the second is the state may also conceive of having it as a heritage, which you are having just for example, the Kamrup Metro District, the District Judges Court. You may have to conceive if you want, if you taking into account that it is a heritage building built during the British era. So this is a very important aspect. Now, as regards this construction of this shed, now another problem which I could notice out there is the construction has been made in that area. Now in certain areas you can't make a construction, but the construction has been made, small buildings have been made, sprouted for construction without any plan. Just for example, this toilet is being constructed nearby to the district court, near to a canteen, and it is just a ground floor small area. Now, by this way, what is happening is it is otherwise taking away the space or eating out of space wherein you can make another construction or bigger construction. This is the main problem which is being seen. So therefore, I'm going on 29 for a visit because of that. I am being the portfolio judge. But this is the main problem. But I think we will have to give you a proposal as regards that as regards the CGM court building, because it has to be maintained as a. I think it has been declared as a heritage. Huh? But somebody was the register administration was telling me yesterday that it has been declared. That is what I was told. It has been declared as a heritage, no? Yes. So if it is heritage, you have, then
have to be
it comes
adopted by
under the funding of not the PWD. It comes under the funding of you have another head na, for heritage building.
Right.
So that aspect we have to look into it. So this is Tejpur. Now, Difu, you have completed.
Completed.
Now, Difu, I am told that the proposal has already been, the proposal for construction of the building. This toilet which is being made in Difu is in the health department's area. Isn't it it is the complex of the health department where we are actually running the, no, health. Health, I am told. Karbi Anglong is health. In the health department's quarters, these courts are being functioning.
Pilot.
So although then we have been given a particular plot of land around 25 bighas, now recently I'm being told that the proposal has been passed. It's a 90-10, isn't it? It has been passed. So we will on the next date seek a as to what is the progress of the tender, because it has already been passed for the
Well-
finance and everything.
That's it.
So just as regards the tender process, what is done. Now, again, in another problem in Difu, I think what has happened as regards the Difu thing in the residential, it has been now, the tender has been floated? Huh?
You don't have any information regarding legal.
No. You seem to be not aware. In Difu, there is two buildings being constructed in an area which have been given, which earlier belonged to an area of the agricultural department. So that land has been given, which is very next to the district judge's quarter. Now therein, there is a proposal of construction of a 4-story, 2 buildings for accommodating the judicial officers. Now, I think almost 6 or 7 months or 9 months back, our Chief Justice Bishnoi has gone there and he had inaugurated. Then there was a question of issuance of a tender, something went wrong. But now I am being told that there is a proposed move for having the tender. Let's find out. I'll
Fine.
record it in my order to that
Lots-
effect. Okay?
Fine.
This is Difu. Now, I take up another issue pertaining to Soraido. Now, Soraido, itu নতুন বিল্ডিং এর কথা বলছো।
Sir Gogoi,
Minor.
Soraido, there is a proposal for a new building, same 90-10. And the old building will be demolished. So now if we spend around, what's the proposal? Half toilets, 46 lakhs, 27 lakhs. Suppose it is constructed, again it will be demolished.
Temporary minor.
And not only that, there is another proposal for some 46 lakhs
46 lakhs for CCTV.
for CCTV and all this thing.
Lots of
These are huge amounts which are
amount.
there.
minor.
So I don't think it makes any sense because these are after all government money, the public money, not
That's-
government, public money. So therefore, something needs to be worked out on the administrative
That's-
side. Now,
If you can expedite this Soraido project, what is the stage now it is pending in? Chief Engineer's office for long,
Then minor, I will have the inspection on that.
almost, is almost 2 years.
It is again a 90-10.
90-10.
So the proposal has been given.
Proposal design is prepared, it is pending.
Lots
The
of,
city-
we'll like to have the.
Now from there it will go to the finance, no?
From district PWD, the proposal has been submitted.
Submitted.
Engineers,
Yeah.
they are technically evaluating the proposal. Not yet.
Not yet approved. They-
Minor.
After their approval, let it go to the committee, Judicial
then it
department.
comes
So
to
it's- then it will come to the.
My lord, my lord. That part, my lord, it may be reflected in the order, I will place the, my lord.
Yes.
As well as to expedite the.
You take a note of these three projects which I have mentioned down there. Yes, any of the judicial officers in, just for example, let's take the case of Buxa. Is there any problem as regards the construction of the public toilet, madam?
Yes, my lord. Now the earlier damaged toilet is now under repair and renovation.
Ah.
And yet not started the construction of the fresh proposal.
Hmm.
And we had received the work order only on 17/11/25.
Okay. So here they say it's a construction of the toilet facility for PWD and transgender individual in the district judiciary Buxa,
Yet not started, my lord.
not yet started. Any
Not yet
other
started.
toilets which are there in your district, madam?
Yes, my lord, those are under dilapidated condition, but presently repair and renovation work has been started.
The repairs are going on?
Yes, my lord, going on.
Okay. And what about the funding you are receiving for maintenance, madam? Are you getting funds for maintenance?
My lord, for last few months, we are not receiving fund for outsourcing.
Okay. So have you put it up with the High Court as well as the departments?
No, we are seeking fund from the High Court
Ah,
and we have placed for FS.
okay.
But Honorable Registrar General informed that due to some issue with regard to approval of the FS, the same is pending, my lord.
One proposal has been mooted in my Buns, my lord. On
Ah.
17/11, a proposal has been mooted, an amount of rupees 1,23,84,000 for outsourcing, my lord, of this issue.
Look, there is one problem, one communication I am sending, my lord, I am placing. Look, there is one problem with capping in the release of fund.
Last
We'll
page.
kindly have a look. This too, this was a letter written by the Registrar General, 18 November 2025.
Hmm.
Capping to.
Yes. Yeah, just 2 days back.
Yes, my lord, but the problem is the capping,
Huh?
the problem is the ceiling limit that has been fixed. Third page, my lord will kindly have,
Where?
third page, my lord. This
Ah.
notification of the Government of Assam, sanction of miscellaneous expenses including housekeeping for all administrative department, senior most secretary, 25,000 per month, extend the power, then subject to budget provision, then subject to annual limit of 2 lakhs. So beyond 2 lakhs, my lord, there is nothing. And head of the department, 1 lakhs. Lord, because of this ceiling, my lord, despite having money, my lord, we are unable to release the fund. my lord. That we have to take the approval and beyond 2 lakhs, there is no provision. If you want to release money beyond 2 lakhs, my lord, then there is no provision. So this ceiling has to be removed so that
Will have to be
when
enhanced.
fund is transferred to the High Court,
Not only from. So therefore, it's ceiling things that could problem with the medication on the silver and t-shirt. But we are not dealing with only one district. So you have to say, when it is a one district, 25,000 can be a limit, but now it's a high court and all the districts will have to remove.
Possible.
It's not possible.
it's impossible.
Or otherwise money is to be straight away given to the district judicial.
No.
Since government has already released the money to the High Court, so where is the question of putting a ceiling? Because ultimately,
That is subject to what my learned
No, no,
brother
it will
said.
have to be as per the heads, my lord. Salary head will be different, my lord, for maintenance.
will
That's why I'm
be,
saying, my lord, it will have to be.
But what about this cap? See,
No, cap, my lord, if it is, my lord, not sufficient, my lord, proposal will have to be mooted, my lord.
no, money is
This
there.
is, this is.
No, I'm
already
not saying that, my
proposal.
lord. This notification will have to be modified. It will be enhanced. That's why I'm saying, my lord.
That
Proposal for
proposal
enhanced.
is given, that is,
That's 18 November.
18 November.
Then they definitely will look into it.
Yes.
They will consider 18 November.
And my lord, last phase of my bunch, my lord, Dorsey will see, my lord, the proposal has been now mooted on 17 November 2025 for an amount of rupees 1 crore 23 lakhs 48,000 for engagement of cleanliness workers on outsourcing basis for 86 sports complexes of Assam. So we have got it recently. It will be moved to the finance department, and my lord, I will place the set.
Then you will have to deal with this also.
Yes, my lord.
Otherwise, if you give this money.
Today's
also,
order,
then
my lord,
you have
Lordship may, yes, reflect this part also, my lord, regarding
Budget
capping
for
also.
what? This sanction of again, this problem, this will be a must.
Now, we also would like to say that you see, the government has a policy of outsourcing sweeper.
My lord.
This is in,
Yes,
isn't
yes,
it
it's
your
there.
policy?
Yeah.
Now, why there are engagements by the district judiciary sweeper
Yes.
on the roll?
On contingent basis.
No, contingents or temporary or
yeah.
whatever
No,
may
the
be,
problem
this is
is
being
that
done.
This outsourcing facility is not available everywhere, my lord. We can have this at Guwahati, Sullivan like this. In the other districts, my lord, this facility is not there. In such situation, my lord, we had to engage person on casual basis or contingent basis on fixed pay to manage the work, my lord. So that is the,
Usually, my lord, this sort of, my lord, engagements are made through tender. For outsourcing also, there can be a tender. Parties who have got such workers, they will, my lord, participate, and accordingly, my lord, it will be settled. In every district, there should be such tenders, my lord. Judicial establishment.
Now, you
Maybe.
see, they are mooting out for an amount of 1 crore 23 lakhs 84,000
Yes, ma'am.
for 86 courts.
yes,
Wages per worker per annum
one,
is-
one has been taken into account, one, my lord, cleanliness stuff. But I asked the registry, why you have kept one? If a one person goes for a leave for 7 days, what will happen? There is also
No.
one irony that has to,
It can be a central kind of thing, tender. and-
No, the moment it is
fund
outsourced.
is not an issue, my lord. I don't think funds should be an issue while, but.
No, no,
facility
no,
is
we are not
there.
concerned with funds. No,
Fund-
Mr. Das, kindly don't take
I'm
it as,
sorry.
yeah, but
I'm
we are not concerned. It may be 10 crores, 5 crores, whatever may be.
Fine.
We are not concerned on that.
Yes.
We are only concerned with what is the problem is being faced out here while taking up the Guwahati High Court bench here. On one hand, the government has made it very clear that there has to be outsourcing. Outsourcing means you can't have somebody in your employment
Yes,
in respect to sweeper.
my lord.
On the other hand, the department is, the some of the courts are still continuing. Our concern is out here, can't it be done by a central recruitment for all the districts? So that everybody, the fund is, we are not concerned. How much is the fund is a different aspect. How they have done it, we have to ask them the money, how much you require. You see, it is not for the finance department to dictate
Yes.
how many sweepers you require.
Yes.
It will depend on the exigency.
Exactly.
But the question arises is, isn't it therefore required when they have also a policy not to have recruitment on this, to have a outsourcing on a centrally recruitment? How, because they are also most probably not appointing anybody out
Yes.
there.
Of course, my lord, everybody is, my lord, out.
How are
except
you
health-
outsourcing out there in the other district when in establishments?
Every establishment will have their own staff, my lord, outsourcing staff. Now, my lord, if somebody is absent, it is the supplier or my lord, that contractor, he will have to provide it, my
No,
lord.
no, we want to understand.
My lord,
Like Mr. Das now says out here that look here, Guwahati, we have this Sulabh and all
Lots
this
of
thing, but there's nothing out there in Dhemaji.
my lord,
So we need to appoint somebody.
my lord.
Now, in the establishment, in the district administration establishment, they will also have a sweeper.
Yes, yes.
How are they managing it?
That, my lord, I will have to have the inspection, but
So
my,
is it, are you doing it on the basis of a temporary basis or contingent basis or a fixed pay basis? Or are you going for outsourcing?
yes,
Because as per him, it is not so available.
my lord,
So you find out that aspect.
my lord.
But at the end of the day, we have to mention that kindly consider this because merely we are asking for a sanction
Yes,
of this particular, the last annexure, the sanction which is being granted
my lord.
of 1 crore 23 lakhs in a year cannot be worked out unless you lift this sanction or modify this communication.
Cap, my lord, yes.
Okay?
My lord.
So we'll pass that order on that. And as regards the others, any other issues as regards the toilets? No. So we'll take up these issues. Okay.
But there are
So today we have therefore taken up, one is the Karbi Anglong, both the issues.
My lord.
Soraido, what has happened to the proposal? Punitpur, that thing we will again further apprise you what has happened because you have to take a call as regards, because if it is being given the heritage status,
Lots of, sir.
something has to be done because otherwise that building will fall down.
Right.
And it will be laughable for the state of Assam that some building could not be protected.
Preserve, my lord, yes.
But there are two small issues, my lord.
Yes.
There was a meeting held on 12/11/2025, by which, my lord, additional budget, because this will also come. Additional budget. Additional budget. Okay. Look, this is the meeting by which, my lord, a proposal for supplementary budget has been placed.
Yes, there is one thing which we could find, please.
It has to be taken care of along with the previous issue.
Now this document,
Minus
minutes,
the meeting.
the
Yes.
first page,
Yes.
you see, kindly see the second page. Further, with reference to para 7 to 11 of the order, the Honorable Court has raised the query regarding the possibility of hiring a nearby building on rent for accommodating the lawyers attached to the CGM establishment. In this regard, in the meeting held on Iman, the SDO of the so-and-so, representative of the Guwahati High Court and the PWD department were directed to visit and inspect the Meghdud Bhavan and BSNL office nearby, the CGM court on so-and-so, and figure out the possibility of a rented premises within the office of the AR to accommodate 1,000 lawyers. The representative visited the said premises and informed that there is no space available at Meghdud. However, the BSNL building, a building and an Assam type house measuring totaling to around 8,000 square feet is available on rental basis. Take up this issue.
Yes, ma'am. Only thing, my lord, so far as the Assam type building is, house is concerned, my lord, some renovation will be required, so it can be.
That is then, that is,
And-
that would save a four-story building.
Fine, my lord. In fact, my lord, one more thing, my lord, in the minutes, my lord, it has been mentioned on 18/11, that, my lord, by 31/1/2026, the shifting will be completed.
Police person.
Plus one.
Person, 2 number, 4 from 7 also probably started the vacation.
Ground floor কোন আছে? বালখানাবোৰ আহি গ'ল। Female lock up. What about the transgender work up, lock up? Are you having one? Male, female to no problem? More particularly in view of the recent judgment of Justice Pardiwala, 2 days back, another judgment has come whereby it has been categorically mandated as regards the 2019 Act. There's a formation of a particular committee.
Hello.
All these things are there. You have a copy of it? Read it.
Fine.
The way they.
You can not post and three from two functioning. More from premise and the also be started after some time. This will be very
Again, second floor conferencing, 90% ঠিক আছে, GR advance functioning. Even completed, vulnerable equipment, public facility common to common project to master.
Yes, when is the administrative tribunal vacating the second floor?
My lord, so far as the second floor is concerned, my lord, I've been told that, my lord, by this week, end of this week, my lord, by tomorrow or by day after, we will get the furnitures. And that will be placed in the second floor, half of the first floor, and that will be shifted to the first floor. Because half of the portion of the first floor will be for the CGM building, the CGM accommodation, and half will be for revenue board and tribunal. So that furnitures are arriving tomorrow or maybe within this week or say by Monday. or
They will
Tuesday.
shift, then this.
Then it will be shifted, then the other part will be completed.
7 ports.
Yes, madam. So ground floor will be, my lord, entirely CGM, half first floor and second floor entirely. So by 31st of January 26, my lord, they assume that tentatively it will be completed.
Now,
By-
so therefore you look into the other
Yes, my lord.
accommodation of.
My lord.
Chalo. So we'll pass that order,
Right.
very long order.
So,
Yes, who are you?
Lordship, we are from Lawyer Session Guwahati.
Yes.
We are filing, Okalkama today itself, Lordship. We are very much interested and, effective, party in this suit. So, Lordship, we are here to enlighten some facts, Lordship. The courts which has been, constructed in the JD building, the new, CGM court, Lordship. You will find the courts are very much congested, first of all. Second, Lordship, you will not find a toilet on the first floor. You get only 3 toilets on the ground floor. This is not in a working condition like that. And there is no proper facilities for the women. And thirdly, Lordship, there is no facilities for the PWD. If someone come, they didn't go to the court, Lordship. That aspect should have been taken care of.
So you mean to say there is no toilets for women
No,
and there is no toilets for PWD?
no, Lordship.
Is there a toilet for transgender?
No, Lordship. And Lordship, if some PWD will come, they cannot approach the court. Go to the court, Lordship. They cannot
There
enter.
has to be a ramp also.
Lordship, that may be reflected, my lord, we'll look into that.
Okay.
And
Okay. So you just give a note out there to
definitely.
him. What are the problems out there? We just put it in our order.
And,
As regards these toilets, that is why I asked. For you may have a male toilet and a female locker, but you also require transgender lockup. You may have a toilet for male, but for female as well as transgender and PWD has to be there. These are mandates as per law. We cannot shift unless we have a completely shift. Now you have to also give facilities for the PWD to go up
Yeah, to
and
the second floor
yeah,
building.
there. Either some lift or something has to be
Yes.
given so that they can very well go there. Because otherwise their right to
Otherwise,
participation is
council
getting
to
taken.
start this
Ah,
Lordship.
strict bar.
Yes,
No.
Lordship.
big one.
Until unless they comply with the PWD, Lordship.
Yes,
Yes,
so
ma'am.
there's a strict bar. So you just give these three for whatever may be. And what else?
Lordship, their stand is that Sejam Court building is in dilapidated condition. Lordship, thing is that the building is in well condition. We our own with our own engineer architecture, we have verified, Lordship. It can be innovated and it can be run another 20 years.
No, it cannot happen.
Lordship.
That part is closed. We can't help that.
So
Mr. Council, the fact remains out there, not today, after 2-3 years, this is a temporary business. Although they wanted to have a 4-story building this way out here, we have not permitted them. This is a temporary business. The main thing is going to come up on this Amingaon, where this place, it will be coming up after after some time, after 3-4 years. You have to manage these, but we need to have the basic facilities like those toilets. Therefore, as of now, we have protected you not to remove you from those area where you are presently occupying. But another thing is, you see, you have to also understand that the rooms out there are not in a good condition. And these rooms of the courtrooms are not, and it is very congested. They may have some space. This is just for a temporary measure. We are doing it. Rest assured, please take note of that. We are going to protect your rights. Don't worry about this. We are going to protect all your rights. And therefore, without your presence also, we have been taking up jealously on this, not to disturb you, without first giving them a proper accommodation so that they can appear. They had given various proposals. One was one of the proposals given to the effect that from the Board of Revenue, that Assam type portion, they will make it 2-story. It means that they are humans, not cattles. So therefore, we have rejected those proposals. We are taking care of that. But the fact that at the end of the day, it is going to shift there.
We are ready to move, Lordship. If permanently will be shifted to one place, Rangmahal, that is our stand from 2023.
No,
If
no.
all courts and tribunal will go, then we will go.
No, this is, Mr. Counsel, you have to understand, this is an internal. So what we require now is the basic facilities which are there. Just for example, as you say, the PWD, the transgender toilet, all these things, these are statutory mandate. If there is not there, your sitting place, you cannot function without a sitting place. So that is there. So without, please take this court's word out here that we are not going to disturb your presently occupation unless they give us a particular area. We are looking into it. That now they have found out something out there, 8,000 square feet area and all. We are looking into it. How can it be adjusted? So with that, if 1,000 lawyers can be accommodated in that, yes, it may be difficult. It may not be possible to have the luxury or lavishness. It may take some time, but you may have the luxury at a later point of time. But as of now, this. Now, as of now, all the lawyers are now having some problems about the parking out here. You can't have the luxury of a lawyer now in Guwahati High Court to have okay, come in the morning at 10:30, 10:45 and have a good parking space. No, this is not there.
Petition to have
No.
good park. Lordship, one more thing is that, Lordship is reflected that our courts, the old courts are very congested. And if you go to the court, Lordship, the new building, these are much more smaller than the present one, Lordship. That should be taken care of. And Lordship,
Mr. Das, you have looked into it? Those courts, have you gone into the new courts, the CGM courts?
No.
How is it? You assist us? You go and have a look at it, and give us a report. Huh? Have a look at it and give us how the court, is it so much, is it so that it is so congested that it can't be done? Have a look at it and give us a report. We'll pass this order in 2-3 days. Just give us a report on that.
And you also give whatever you want to say in a small, one page.
One piece.
Definitely,
Huh?
sir.
So these are the things, not much.
no, Lordship.
I'm,
we are-
no,
we are
m-
seeking
m-
much,
m-
Lordship.
Mr. Counsel, what I'm saying out here is we are going to look into every aspect, but
Definitely.
for the time we need the basics. Once these basics are there, we have to tell them that these basics are there. So therefore, kindly give that note which are there.
There is one small player that is, we need
This
a-
is kindly consider that this is a bench which is not adversarial to anybody. It is for the benefit of all. We are just looking into it on the judicial side that these are there. Just for example, those toilets which are required. Those toilets are required, so we are looking into it. We are not there to that effect that this person should get the contract or that person. We are not on that. So therefore, you give that note and you also have a look.
So that
To
you
that
can
we
involve in
will
the
pass that
order,
order.
This is your grievance. And
But
Mr.
tomorrow we'll
Kapoor
get-
said he will look into it and will in the meantime
Tomorrow I'll
say
go
to
and
have a report from you.
Tomorrow I'll go and.
You go and give a report.
Yes.
Just report means you just give us a detail out there
Oh, my.
and
Next
so
date,
on
my lord, I
that
will
basis.
place
we
the,
do.
my lord, area of every room, my lord, in every floor, what will be the size of the room and all, I will place it.
Exactly. Lordship, two speed breakers should be there, Lordship. Few days back, two advocates has been met in an accident. So we have to cross the road. Lordship, kindly for the time being.
either some police person.
Yes, yes,
or-
traffic will
That-
also
that
be.
also
traffic
be done
will-
immediately.
Immediately, Lordship,
Immediately.
because there
That
is
should be
unfortunate
done immediately.
incident last,
Well,
I think,
then
Friday.
that direction should be directly reflected,
Ah.
my lord, will do the need. I will convey, my lord.
You just put it there.
Definitely, Lordship,
Will
definitely.
pass.
Deeply applied.
One small prayer, if I can, my lord.
Yes,
One small.
Because I was told to place this, my lord.
your small price has gone more.
No, no, no,
No
not that long, my lord. My lord, Ekon, status of creation of infrastructure. Look, here, my lord, Lordship will kindly have a look. There are, my lord, 18 judicial officers whom we are unable to give appointment because of the lack of infrastructure. Lordship will kindly have a look or into this, my lord. This, because, and apart from that, there are places like, my lord, Civil Judge Junior Division JMFC Bozali, lack of fund for purchasing furniture for temporary courts. Then, my lord, for Kachar, we have made it bold, my lord. However, there is lack of fund for purchasing furniture. We have made the temporary courts, but there is lack of fund for purchasing the furniture, because of which the temporary courts also could not be functioned.
Mr. Just a minute. Mr. Das, you
Yes.
just verify so far relating to Soradio, I think that fund is already
Soradio,
serial number 4 for this courts in the Deputy Commissioner's office. I think
yes.
that has been completed, fund.
You do one thing.
Furniture also I have signed, I recall it, I have a portfolio.
They have given a proposal for 12 lakhs. But we have fund for only 2 lakhs. That only, we have already transferred that 2 lakhs.
No, it's okay.
The additional budget.
No.
that
This
that this will come.
office will be shifted? Any idea?
Which one, Nathi?
Soradio?
Soradio, the 2 court links are already ready in the district.
No, I know that, but the proposal is that this, they will shift to somewhere else, Deputy Commissioner's office. Then we'll run temporarily from Deputy Commissioner's building and we'll demolish the old building and start construction.
We do one thing. Mr. Gogoi, you have a look at it. We take up only this matter next Thursday. Only this matter at 3:30,
Only thing, my lord, what I say, my lord.
as well as the CGM thing.
No,
You give the CGM, where is the CGM, you give it today itself, by tomorrow morning. You will look into the CGM thing and or you go tomorrow and look into
Yes,
it. Day
yes.
after we are passing,
Fine,
only the CGM and this one will look on that day.
fine,
The others we will consider
Yes,
later on.
fine.
I'll pass an order.
You give a copy to. Mr.
Uh,
Yeah,
you
I have
have-
already given me. I have already.
To next Thursday, I'll pass an order.
Please, I one.
Did you file any additional pleadings?
Sorry?
Did you file any additional pleadings? The Kohima bench, Mr.
No, Lordship, I did not. Lordship, the difficulty was that the petitioner could not come to Kohima because of his ailment. He was not feeling well. The petitioner could not come. But on the question of delay, Lordship, I have placed one judgment of the Supreme Court, which was emailed this morning. This is exactly on the subject, Lordship. Lordship has received that.
So here it has been given for 3 years.
Yes, Lordship, the consequential relief. The principle is that, Lordship, this is a continuing wrong, recurring wrong that has been committed. Lordship, after the respondent has ported me out of job, they have not paid me. And every month that wrong has been committed by not paying me.
So any area to be paid will be from 2021.
Lordship, since yes, this is 24 months, yes.
It can't be before that.
Yes. Lordship, the petitioner is seeking for the small benefit, not a big one, Lordship. Whatever,
But there will be areas,
Lordship.
or you don't want the areas.
Oh, we want, Lordship. Why not?
Therefore, the areas have to be limited.
It has to be limited as
Happened
per
long
the,
time back.
yes, Lordship. As per the judgment of the Supreme Court, it has to be,
He has approached this court very long, after long time, na?
Lordship. That I can say, Lordship. In spite of the.
This person concerned was Medical Board 93.
Lordship.
You submitted legal notice only in 2023.
Lordship. So,
And then you have, yeah.
I have represented on earlier occasions also, Lordship. In 2009,
Good, but these representation which you have given is upon a
2009.
discharge submitted. See, after 93, you gave a representation in 2009.
yes, Lordship, one is earlier to that, but it is not dated.
Hmm?
One representation was also submitted early prior to 2009, but there is no date on that. I have placed it in my petition, Lordship.
Well, which is the judgment you have referred to, Mr. Counsel, earlier?
Dharamveer Singh, Lordship, that is
Oh,
2000,
yeah, Dharamveer Singh.
2013, 316. And judgment of this court also I have produced by Justice R.D. Chaudhary. And this court has followed the judgment that has been rendered in Dharamveer Singh. 99.
So, Mr. Imsong, we will pass an order thereby giving him the benefit, but that benefit will be only taken from 2021.
Lordship, may I just, 2020, from 2020
No,
was a COVID.
I was thinking about 2023. 23 will be the right period. You have approached after 2009, you have forgotten everything.
I admit that it is late, but then consider the fact that from 2020 there was a huge pandemic all over the world. So if Lordship can consider at least from 2020.
Mr. Imsong, 2021.
Lordship, my objection for time, because after so much time, kept only approach. That may
So
be.
therefore, therefore, I am not giving him the benefit for almost 29 years. I am not giving him the benefit.
Lordship.
So he is not getting the benefit till for 21 years and another here 7 years. 28 years, he's not getting any benefit.
Lordship.
So he'll be only getting the benefit from 2021 onwards. So
Why
the
not?
areas will be counted from 2021 onwards.
Because in
Not
this
bad.
case, in the case that I've cited, Lordship, they have given for 38 months. In the case that I have cited today, in Dasham Singh case. The High Court has given, a single bench has allowed for 38 months. And the division bench reversed it and gave it to whole benefit. But the Honorable Supreme Court,
Kindly see the last paragraph, paragraph 6. In this case, the delays of 16 years would affect the consequential claim for arrears. The High Court was not justified in
Yes.
directing payment of arrears relating to 16 years and that too with interest. It
Yes.
ought to have restricted the relief relating to the arrears to only 3 years before the date of the writ petition.
yes.
So
Lordship,
relying on a judgment, I cannot now enhance more than that.
I'm just pointing out, Lordship, in the single bench, it was given for, the relief was granted for 38, and they have not reversed that. In the last paragraph,
So
Lordship,
you want to say that I should give you for 38 months, then the division bench should give you more than that. And then the state goes to the Supreme Court and Supreme Court now says that, okay, this judgment is there, so therefore we give it for 3 years. Don't come up with that submission. Hello, disposed. We'll pass that order.
Lordship.
obliged, Lord.
Yes, affidavit file. Oh, থাকি জানো? So they are doing it.
Lordship, affidavit has been filed by the government, Lordship.
That you are going to provide, na?
Lordship.
That is why you don't see the petitioner counsel appearing. Where is that affidavit file? 11/11/2000, Iman. 11.
11/11/25, Lordship.
So here, paragraph 3, na?
Lordship.
None appear. Are you appearing for the petitioner, madam?
I'm appearing for Senior Advocate Mukpartin for Guwahati High Court, Standing Counsel for Guwahati High Court.
Okay. None is appearing for the petitioner. Okay, none appears on behalf of the petitioner on call. Mr. Arun Chandran appears on behalf of the state of Arunachal Pradesh. And Miss so appears on behalf of the Guwahati High Court. Itanagar Permanent Bench. The petitioners herein who are staff drivers working in various subordinate court establishments of the state of Arunachal Pradesh have filed the present writ petition seeking directions upon the respondent authorities to formulate promotional scheme for the post of driver with the graded structure under the Arunachal Pradesh State District Court Service Rules 2013. Full stop. When the matter was taken up by this court on 24/7/2025, this court had put a query upon Mr. P.K. Tiwari, the learned senior counsel who represented the petitioners as regards Rule 29 of the Arunachal Pradesh State District Court Service Rules 2013, whereby the service conditions not so mentioned in the said rules of 2013, but which is, otherwise applicable to all the state's civil services would be applicable to the members of the service coming within the ambit of the rules of 2013. Full stop. This court further inquired as to whether any similar notification pertaining to certain benefits given to the drivers in the state services have been issued. Full stop. This court thereupon fixed the matter on 21/8/2025 for further consideration. On 21/8/2025, the learned senior counsel who appeared on behalf of the petitioner submitted that although the MACP is applicable to all employees of the government of Arunachal Pradesh, and the petitioner herein would also be entitled to the benefit on the basis of Rule 29 of the Assam Arunachal Pradesh State District Court Rules 2013. And as such, appropriate direction has to be issued so that either the state provides avenues of promotion or apply the benefit of MACP to the drivers. This court, by the order dated 21/8/2025, requested the Learned Advocate General Arunachal Pradesh to appear in the matter, taking into account that any such directions would have an implication in respect to all drivers who are employed under the services of the state of Arunachal Pradesh. Full stop. Accordingly, the writ petition was fixed on 18/9/2025. Full stop. On 18/9/2025, the Learned Advocate General of the state of Arunachal Pradesh appeared and submitted that the government of Arunachal Pradesh would like to bring on record their stand by way of an affidavit as to whether the drivers employed in the services of the government of Arunachal Pradesh are being provided the benefit of Modified Assured Career Progression Scheme. Accordingly, this court directed the listing of the matter today, that is on 20/11/2025, and the affidavit was to be filed on or before 17/11/2025. In pursuance thereto, an affidavit was filed. An additional affidavit was filed by the respondent number 4. So paragraph 3 of the said affidavit being relevant is reproduced herein under. Page 101, 102. From a perusal of the above quoted paragraph, it is seen that the benefits of the Modified Assured Career Progression Scheme have been extended or provided to regular drivers as per the Modified Assured Career Progression Scheme, as there are no promotional avenues for the drivers serving under the various departments of the government of Assam or Arunachal Pradesh. It was also mentioned that the drivers serving under the district judiciary shall also be eligible to avail financial benefits under the modified assured career progression scheme at par with the drivers of other departments under the government of Arunachal Pradesh. Taking into account the said stand of the government of Arunachal Pradesh, this court therefore disposes of the instance with petition, observing with the following observations and directions. The regular drivers working in the district judiciary of the state of the various district judicial establishments in the state of Arunachal Pradesh by dint of Rule 29 of the rules of so-and-so would be entitled to equal treatment and would further be entitled to the benefits of the modified assured career progression scheme. Number 2, the respondent number 1, the Guwahati High Court, as well as the state respondents are directed therefore to do the needful. So the benefits of the modified assured scheme is provided to all the drivers, all the regular drivers working in the various district judicial establishments, in the district judicial establishments in the state of Arunachal Pradesh. With the above, the petition stands closed.
Much obliged.
Much obliged.
Item 6, LL's frequency.
Yes, what is this?
The last occasion, if your lordship kindly produces the last order dated 10/11/2025, your lordship had granted the last chance to the respondents to file an affidavit. And pursuant thereto, the state has not filed any affidavit, but the private respondent number 5 had filed an affidavit. And if your lordship kindly turns to page 272 for a moment, my lord. Page 272.
What is your case about?
Pursuant to the last order, as it appears, they have abandoned the standard process and have floated a new tender. If that be so, then my lord, nothing survives. Page 272, my lord.
Yes.
My lord, a new tender has been floated, my lord, but subsequently the fact of the case is that, my lord, the private respondent was initially awarded the respect of dietary articles to the Nagara Civil Hospital. Thereafter, my lord, although the private respondent was adjudged as L1, my lord, but that was not awarded to him because of the reason that, my lord, the authority found that the rate quoted by the private respondent is very low, my lord. So for some time, my lord, it was not granted to the private respondent. Then private respondent approached the Honorable Court. And in terms of the elections filed by the during the pendency of the petition, my lord, the process was initiated to award the contract to the private respondent, and subsequently it was awarded. Subsequently, the risk petitioner again came up before the Honorable Court on the ground that in the year 2023, my lord, that work of supply of dietary article was awarded to the risk petitioner for a period of 2 years, my lord. But that was not without any. That was not by following any tender process. Since the risk petitioner was the existing supplier of Test Medical College, my lord, So on that basis, after establishment of the Nagaon Medical College Hospital, my lord, the petitioner was awarded the work for a period of 2 years. So during the subsequent of that contract, since the private respondent was awarded, then the petitioner approached the honorable court by way of the instant petition. So this, in the instant petition, initially there was an status quo order passed by the honorable court. So subsequently, my lord, after expiry of that 2 years period, my lord, for which the petitioner was.
Anyways, what is he challenging here?
Well, my challenge is the order they took, my lord, if you lordship see my prayer at page 17.
His challenge was that, my lord, during this order detailed substance of.
Was the decision of AIA to award the work order in favor of Iman as contained in the letter dated so and so?
Yes, it was awarded.
Decision of curtailing the tenure of the agreement. The agreement has gone.
That has gone. Second prayer has become, my lord.
Infrastructure. So now as regards the award, the work order in favor of the private response number 5.
That challenge.
Where? Where is that
That
award?
order is, my lord, at page 55, my lord.
Page 55.
Page 55.
Negotiation of AIA, both parties agreed to the following. Ranjit Borwa as L1. Who is Ranjit Borwa?
Well, private response number 5.
Okay, was L1 for supplying of AIA inpatient. Ranjit Borwa has convinced that he would be able to provide food at the. Oh, that was some clause was
Yes,
there.
yes.
Yes, yes.
Now, my lord.
That as the original tender was opened on Iman and already 10 months have elapsed and Ranjit has already submitted bank guarantee away, hence a guideline is solicited regarding the starting of a tenure of the work and extension of Iman is required. In view of the above, it is decided that Ranjit Borwa is to be awarded. Now, you have given up this.
Latest position to page 272. Latest position, my lord. As on there. Page 272.
272. What is this? To Ranjit Borwa, your correspondence regarding the High Court's verdict on the worker. This is to acknowledge receipt of your letter concerning the High Court verdict in favor regarding the work order for so and so. However, as per the official, the validity period of the said work has already expired with the last date being so and so. In the greater, a new tender for a year would be floated on 15/10. Tell.
Has been quoted, my lord, but subsequently, the next page, my lord, page 274, the Ranjit Borwa again put down the authority, my lord.
Then.
Saying that, my lord, since there were, my lord, some force measure for and on the basis they were paid for validity of the agreement for a period of 1 year. Since, my lord, they have not been allowed to work till date, my lord.
Then.
So, my lord, now, although the tender has been done, my latest instruction is that although tender has been quoted, but it has not been obtained. So whatever your lordship directs, my lord, accordingly. We will.
No, the tender was of the year 18/11/2023.
Yes.
The period of the contract was for what period? No, we are also to understand, you see, these are dietary products for the patients.
Yes.
The one thing is that the state can very well take somebody's at a less price. There's no quarrel with that. Although there is a clause to that effect that there is a medical board or something which fixes the price and it cannot go below that. So that is one aspect, which was apparently there was a violation by the respondent number 5. But whatever may be that as it may, you now want to travel to that notification of the governor as regard the procurement and say that, okay, you will take more additional security. Then on what basis can you take him if he is less than that particular clause?
No, during the initial proceeding, my lord, the earlier proceeding, my lord, that was the stand. But since the private respondent approached the honorable court, my lord, so thereafter a discussion was held with the private respondent by the authority. So they agreed because they were supplying the.
No. We are also concerned about the health.
Yes, my lord. On
That
the ground-
these are dietary food for them. Now, if you want to go for that, now you have already floated a tender. Now, once you have floated a tender, that means you have cancelled the earlier process.
Yes, madam. Yes, my lord.
Unless there is a challenge to the tender process, can you stall it?
Whatever your lordship, my lord.
I am not going to, what is there? So nothing further remains. I can only say that in view of your decision to float the tender, nothing remains here.
Lordship, so far as.
No, you don't have a
Lordship,
case.
kindly say how this this reputation has come. Page two to seven.
Whatever may be, he has come, whatever
No,
may be.
not
You
the-
see what you have quoted, you quoted less than their figure they have arrived at.
Lordship, I understood Lordship concern, but Lordship kindly see the NIT. What is the directly come to?
No, they have now
There is
thought
no
of
ceiling. Lordship.
going for a fresh year. Now they have already floated the tender. Now this is a subsequent, you have submitted a representation. Your representation have not yet been considered. I'm not on that. But as on date, his decision is that they are going for a fresh tender. Why should I now deal with this aspect? Unless you challenge this fresh tender.
Thing is that Lordship, whether they are entitled to this prayer number A. Now, in this
Prayer
respect-
number A or B, C, D doesn't matter. It has now become infructuous. The question is, the moment they have gone, you have to challenge the tender. You have submitted a representation. They have not considered it.
Lordship, kindly see the language of that letter. Their letter. They seek.
They have gone for a fresh tender.
No. They have said that, but what is the language of the letter, Lordship? Kindly.
What is that?
272.
What is that?
However, as per our official record, the validity period of the said work order has already expired. This is wrong. With a last date being 21/10/25. This is wrong. In greater public interest.
So this is wrong, so you need to challenge this.
No, now, Lordship, what they have asked by this? In the greater public interest, a new tender for the diet service of Nagaon Medi has been floated on Iman. This is for your kind information and necessary action. If you have any objections or representation in this regard, you are requested to submit the same on or before 31st/10/2025. So accordingly, we have filed. Now, Lordship, kindly see for a moment our work order, LOA, at page 227. Annexure 15. How this have come? Order to please, order to. go to
Yes,
the-
Mr. Borua, where is the condition? That condition you showed me on the last
Second thing,
occasion,
sir,
no?
that's
They
what I
have
said.
to have that,
3/10/24.
they will fix a rate. Where is that?
Page 33 is the tender, my lord.
Where is that? There is a board which is going to fix the rate. Isn't this the same case?
No.
There's another case.
That is already disposed of by your lordship.
Okay, now this is another one.
It's Testu Medical College, man. This is Nagaon Medical College.
Here, Lordship, no ceiling is there. That is why I want to show the relevant portion at page 182 of this bid document, Lordship. Evaluation of the offer of award of contract. 182 page, part of the bid document. The Nagaon Medical College and Hospital.
Okay, now why have you challenged this 29/2024?
I have challenged this on two grounds, my lord. The first ground is at the rate which they have quoted, it is impossible to provide good and nutritious food to the patients.
But there is no viable rate.
There is no viable rate, but that is the stand of the government. If your lordship kindly turns to page number 50 for a moment.
50.
50. Basically, my lord, what had happened? There was a tender.
Yes, what is this?
So what had happened, my lord, after the tender process was floated on 8/11/2023, although they were the lowest bidder, they were not given the word contract. So they came before this honorable court by filing WPC number 1878 of 2024. And this was the defense of the learned standing council health department before this honorable court, page 50. Kindly come to fourth line, my lord, fourth
The
paragraph.
work order is not issued to the petitioner for the reason that the rate quoted by the bidder is too low. And at that
That
rate,
rate
nutrient cannot be supplied.
Cannot be supplied.
Yes, then,
And the next paragraph is, it is further instruction of Mr. Boda, London Secretary Health Department, authorities are having apprehension that at this rate, quality food cannot be supplied.
then
And
Be that
The
as
same
it may, as
thing is
Mr.
the
Bora
rule.
for so and so 6.5 prayer is allowed. However, we clarify what should be the rate at which the air can be supplied according to them.
Yes, my lord.
Now thereupon, what the matter has been disposed of.
That has been disposed of.
Where is that?
My lord, disposed of after, my lord,
Where is the order?
order of disposal, my lord, will find at page number 59. Page 59, my lord. So after this order.
We
there
of
will
that
be some-
area, so and so, the petitioner attended the office of the Imam and a
Second
subsequent
paragraph.
order has been passed on so and so by awarding the contract in question to the finance of 1 year.
Negotiation
to
of
the date
the
of so and so. Okay, where is the work order?
Work order, my lord, that decision is at page 55. The impugned decision.
No, where is the work order? Because there is a work order, an order has been issued on 29/2024. Where is that?
Lordship, our work order LOA is at 227 in my in opposition.
227.
And this is pursuant to a court's order.
There is no court's order.
There's no court.
There is no court's order.
Yes, Lordship, kindly see the.
No, Mr.
language-
Soman,
No, no, I do.
you are requested to start the dietary supply from 1st of November. You are requested to submit the signed contract in so and so. And being the L1 bidder for the said so and so dated, you are requested to start the dietary for Iman from 1st of November. Why do you say that for 1 year?
NIT for 1 year.
Conflict. with-
NIT was for 1
1
year.
year. And Lordship, kindly see the order at 221, that really, this order, pursuant to which order this has been, this development has taken place. 220 is the IA and 221, order dated 18/9/24. The grievance of the petitioner is that even after the petitioner being declared as L1 tenderer for supply of diet to the in-house patient at Nagaon Medical College and Hospital, and even after completion of all the formalities, the final work order has not been issued to him. The present IA is filed seeking stay of communication dated 18/7/24 issued by the respondent number 4.
So what negotiation you had?
Yes, the Lordship, kindly see that page, page.
Whether the rate quoted by the private restaurant, whether in that rate, it is viable to supply the dietary article or. Subsequently, after the negotiation, my lord, the work order has been.
So you change your stand.
They changed it.
No, my lord,
No, they say they are able to serve. You only submitted, then it is not possible.
yes, my lord.
So now you think that it is possible.
Yes, my lord. Subsequently, because they thought something that is on even by.
Now what do you want? Do you want to give it to him?
Oh, my lord. Now, he is that because now whatever is the complication, because they are
No, you tell me, you want to give it to him or you don't want to give it to him?
whatever.
No, I have nothing to do. If you want to give it to him, I can say that, okay, dismiss, you go ahead. If you want to don't, I can dismiss his case. Don't worry. Either of it. I am very flexible, my orders.
Opening the environment,
No, you want to open or not?
whatever, because they are also not in a position to decide what to decide. So, because of the pendency of this case, so whatever. is
Okay, we will make it very clear. Have it next week and say that, okay, you can open, take a decision and place it before this court. Pendency would not be a bar.
Whatever decision.
But you don't have a case. The dietary thing is not there. They have quoted such
No,
low
Lordship,
rates and
they are-
this
no,
is what is being
Lordship,
given,
if
and now 1 year has gone, inflation has happened and you are going to give it at that
No,
rate.
they kept in, no, Lordship, a negotiation is provided under this bid document. There is a mechanism how to check the quality of food and quantity. of
Now
food.
who is supplying?
In violation of this court order,
Either the petitioner
it's
or the
continuing.
respondent
No, there is no violation of this.
Yes,
court order.
Lordship,
I have
yes.
allowed them to do it.
Yes, Lordship, kindly see.
I have given it very in the meantime. However, this court makes it clear that the respondent shall not finalize the NIT till the extent. However, the REA is given power to make alternative arrangements for supply. Yeah? This order is there 4/4. Now we do one thing.
No,
Let the
no, 4/4 is vacated, Lordship, kindly see. at page three. That is what today there, what is the order today? 320, so kindly see, page 320. We have filed one IA for modification of this order. Then this order has been passed.
What did it say?
Paragraph 9, I'm reading, Lordship. Regarding the aforesaid work order, our work order, it is apparent that the aforesaid work order issued on 21/10/24, that is mass prior to passing of the interim order, that is 4/4/25, after negotiating with the applicant respondent number 5, as per order of this court, dated 18/9/24, passed in IA number 262, 2612/24, whereafter the applicant was directed to start the dietary service for the patients of the Nagaon Medical College and Hospital in continuation with the subject tender work for 1/11/24. It further appears that thereafter on 23/10/24, the petitioner submitted the signed copy of the agreement.
No, kindly see page 321.
That is what Lordship kindly.
No,
Yes.
because of this, we allow.
No, Lordship kindly say.
We
According,
allow his repetition. Don't make this type of submissions. Okay.
Lordship, accordingly,
Hard
interim.
mistake. No, you go division bench. Don't come up with this type of submissions, Mr. Counsel.
No.
Page 321 is very clear. See,
No, that is not extended, Lordship. That word is not extended.
what no extended? I only said that as regards 1811, but you can very well continue. But it is not extended. Accordingly, the interim order passed on so and so to the extent only that the prisoners are permitted to make a so and so to the patients in the said hospital and not to finalize till the next return
Is not extended. Is not extended.
Ah.
So that ends there. That for that private this thing.
Okay, we now again pass another order saying this is to be bad. Don't worry. How can he pass that order when this order is being passed? Okay. Heard Mr. A.K. Burwa, the learned counsel, appearing on behalf of the petitioner. Mr. J. Deka appears on behalf of the private respondent, and Mr. D.P. Bora appears on behalf of the Health and Family Welfare Department. Full stop. It is seen that pursuant to the order passed by this court, it is seen that on 15/10, it is seen that the petitioner herein have assailed the instant writ petition has been filed assailing the decision of the respondent authorities to grant the work order in favor of the respondent number 5 dated 29/2024. Full stop. A perusal of the order dated 29/2024 reveals that on the basis of the notice inviting tender dated 18/11/2023, the respondent number 5 was permitted for supplying of diet for patients for 1 year with effect from the date to be decided once the guidance as mentioned in point number 3 is made clear. The record further reveals that on (21/10/2024), . 2024, The petitioner was, the respondent number 5 was requested to start the dietary service for patient of Nagaon Medical College from 1st of November 2024. And in that regard, to submit a signed contract in stamp paper for the same along with the security deposit. Pursuant thereto, the respondent number 5 had submitted his acceptance to start the kitchen and dietary service with effect from 1st of November 2024 and entered into an agreement on 1st of November 2024, which would be valid for 1 year from 1st of November 2024. Full stop.
It was kept in abeyance, page 235.
Hmm?
Page 235, it was kept in abeyance, this agreement.
Who?
Page 235.
There was a status quo order on.
Because of this
28
repetition.
2024, despite such matter, they entered into an agreement,
No fault on our part.
direct violation of court's order.
Thereupon, in view of an order passed by this court on 28/10/2024, comma, the work order dated 21/10/2024 was kept in abeyance. Full stop. The record reveals that this court, by an order dated 4/4/2025, vacated the order dated 28/10/2024. On the ground that there was no valid agreement with had vacated the order dated 28/10/2024 and further observed that the authorities of the Nagaon Medical College and Hospital be permitted to make alternative arrangements for supply of dietary articles to the inpatients in the hospital. This court further directed that the respondents shall not finalize the tender NIT dated demand till the next returnable date.
That has been modified at page 253.
Where?
253 page, annexure 20.
254.
253.
108 also, Your Lordship.
253.
Same thing. Page 108. Relevance portion 120.
Untuk kuisa, 100 ki kuisa.
While another order passed by this court on 26/9/2025
Property portion para 10 and 11. Two six space.
the learned coordinate bench of this court vacated the interim order dated 4/4/2025 Pusto. It It is further seen from the records that the respondent authorities, more particularly the principal cum chief superintendent, Nagaon Medical College and Hospital, Nagaon, had informed the respondent number 5 that the validity period of the work order had already expired, with the last date being 21/10/2025. And in greater public interest, a new tender for the diet service of Nagaon Medical College Hospital have been floated on 15/10/2025. The respondent number 5 was also given the liberty to file an objection or representation in that regard on or before 31/10/2025. Pursuant thereto, the respondent number 5 had given a representation thereby requesting the respondent authorities to refix the validity period of 1 year However, the said representation have not yet been considered. This court inquired with Mr. D.P. Bora, the learned counsel appearing on behalf of the Health and Family Welfare Department, as to why the representation of the petitioner have not, respondent number 5 have not been considered. The learned counsel submitted. When was this representation submitted?
31st, Lordship.
Where is the acknowledgement?
We have sent by this mail, Lordship.
Huh?
There's no acknowledgement.
Mail,
Where?
through mail.
273.
273.
What is the date?
That is right side, Lordship. It's not very much legible.
Then how do you know that you have submitted on or before 31/10?
We have submitted, Lordship.
How do you know?
We have made statement, Lordship, here.
You're mentioning doesn't do
Affidavit.
no. There is an acknowledgement. They have directed you to file it. Like
Even
you
my
see earlier, page 280, there's a stamp.
Yes, that is there. That is by hand, Lordship, we have given. But this one is by mail, we have.
Why have you given by mail?
Because he is from the Dibrugarh, Lordship.
Huh? You were given such a long time, then you have not submitted. 272 is what page?
They got
When were you given? 272 was given on 15/10. You could not submit.
No, we have submitted on time, Lordship. That is, the last date is before 31st/10/25.
Then when
On-
did
on
you
same-
submit?
On same day, we have submitted.
How do you know?
Lordship, this mail is there.
Where is the date in the mail?
Here, Lordship, it is not very much legible
Then-
because
There's no date.
my learned friend also submitted that we have filed this.
There's no quarrel you have submitted.
I understood, Lordship.
Yeah, then it is not
I'm
there.
apologizing for that because
No, can't help it.
while
Anyway,
printing.
Mr. D.P. Bora, the Land Council Family Welfare submitted that in view of the pendency of the instant writ petition, the respondent authorities have not considered the representation. He further submitted it is not known as to whether the said representation was submitted on or before 31/10/2025, inasmuch as the records does not show that it was submitted on or before the said date. Full stop. It is the opinion of this court that the respondent authorities have already taken a decision to go for a fresh tender in view of the lapse of a particular period. In view of the fact that the agreement period had already lapsed. Full stop. In view of such a decision being taken, comma, it is the opinion of this court that the instant writ petition cannot further survive in view of the fact that the respondents have taken a decision to go for a fresh tender. It is further observed that this court has not opined anything as regards the consideration of the representation which was submitted by the respondent number 5. The same is left to the wisdom of the concern of the respondent authorities. Under such circumstances, this court therefore does not find anything for the present writ petition to be adjudicated, for which the writ petition stands closed.
Lordship.
I've not said anything. You do whatever.
Yes,
you-
Lordship. Let them decide, Lordship.
Deeply.
We also not got the fruits of our writ petition, earlier writ petition. We also not got the fruits of earlier writ petition, Lordship, in this.
In the new tender process, they have not even participated. My instruction is that.
Obliged, Lordship.
Or this one. He does the learned counsel is appearing on behalf whether the petition is agreeable to the court. Oh, yes. Mr. Dasgupta, anything?
No, your lordship, give that proposal. Yep. I have convinced your lordship.
What do they say?
They have agreed. They want that if something, some interest we. The matter is.
Let us
if
have
they
that.
will
I
get
said that
development,
some, I made it some 1 lakh each, no? Something like-
41.
Huh?
That comes to 41 ex gratia.
Ah.
1 lakh each 41 that we have agreed.
So if that be so,
Plus 23. Plus 23.
Ah.
So that comes around
the
60
41 plus 23.
23 point something.
You gave me some proposal. Where is that proposal? Ah, yes.
Yeah.
So it was, you said 25, I said 23.34 plus 41.
Yes.
Then how many workmen are here?
41 according to you. Yes, 41.
Okay.
I don't know.
So you have a representative organization.
Yes, union is there.
So you do one thing, both of you file a joint affidavit about this 41 and so, and then file it, we close it. And then it becomes a decree of the court and you get the money.
You are not doing that.
I think that is the best way.
Yes.
Both of you file and it has been submitted by the learned counsel appearing on behalf of it has been submitted by Mr. A. Dasgupta, the learned senior counsel, appearing on behalf of the petitioners, that the petitioners would be agreeable for a ex gratia payment of 41 lakhs plus 23.34 lakhs
That is gratuity,
towards
both. Gratuity and
retrenchment benefit,
Both.
gratuity and retrenchment benefit. Mr. R. Sharma submits that he had also communicated with the respondent number 1 or 2,
both the company and the director.
No, okay. Respondent number, respondents herein.
Yes, ma'am.
And they are also respondent, one respondent herein, and they are also agreeable to the said amount. Accordingly, it is the opinion of this court that the said aspect be brought on by way of a joint affidavit filed by the representative of the petitioner, or by the petitioner, filed by the petitioner as well as the respondent. Full stop. When can you file?
I can file it within a week. Only two aspects, your lordship. Our client is seeking a time of 6 months, if that is.
No time bound. You finish it off within 60 days. I'll
60
give that,
days.
no, you say that, I'll pass the direction.
Okay.
Within 16, not, you can't, this is
Fine.
the matter going on from 2014,
And
shameful.
Another request is that, your lordship, on the payment of the last due, they should vacate the quarters.
Vacate the,
Quarters, on the last due. They are still occupying the quarters. So on the payment.
no,
of-
you put it there in the
There,
agreement,
yes.
in the affidavit.
You should give some time here, by the affidavit. Some time can be allowed to.
No, then you agree to 6 months.
No.
No, you agree to the 6 months.
Final.
Oh, within how much? 15 days, 10 days?
Little bit 2 weeks.
Huh? 2 weeks? Okay. Well, let us have this ended this year.
As you also did.
Yeah. That's it. The said affidavit, joint affidavit be filed on or before.
John will be individual affidavit. We shall file our affidavit, they shall file it. Let them file their affidavit, we shall file our affidavit. Again, joint affidavit, we have some problem. We shall just, as you are dictated, we shall file this affidavit.
Now,
That will
then
be
you
done.
say, you see why I wanted the joint affidavit, then it becomes a form of a compromise decree, nah?
Right.
I'll make it a point of a decree. If you can file it. You see, the terms are very clear. 41, 23.34. If I give him 6 months, if you want 6 months, how much time would you like to for vacating the quarters?
That I have to discuss.
So that will depend. Their last payment will be at the time of vacating. So they pay the entire amount, you vacate. So if you want 6 months for vacating, then it is a case that the last payment will be made within 6 months. That is what.
I should simply convey them,
Huh.
they will file an affidavit in terms of the order passed by your lordship. They will do. And then the
To file the affidavit, I just say affidavits. Affidavit bracket
But
S.
joint affidavit will make clear some problem.
Affidavits. Huh?
Some ego problem.
But you
will
have to
come.
vacate also. Yeah.
Some ego problem will come again.
Otherwise, yes. List the matter on 10th of December, 11th of December.
11.
11th is, today is what? I will already given
Then it
more
will be
than,
after 18th of December. Lordship, that will be.
we have only one day. 18th, 19th is there, 20 close.
Then before 10, before 11, 10. The day.
He can file within a week. There's no problem. I'm asking about you because you have a more people giving an 11th.
No, my son's marriage is on 15th.
Huh?
My son's marriage is on 15th. That is the problem. Then your lordship can have it before. Before it can be.
9th?
9th
9th? Okay, 9th.
oblige.
তাতে এটা লাইন এটা লিখিব in those affidavits both the parties shall indicate as regards when the quarters are required to be vacated.
Oblige.
Oh yes,
Industrial tribunal matter. Lordship has indicated about Gujar judgment.
which one?
Gujar judgment.
Ha. Now applying Gujar end date, then I think you can get it, don't you think?
I wanted to, the proposition, the judgment my learned brother relied on, that is Gujarat judgment. I want to have a study on that, my lord.
You have a?
I want to go through it on that particular subject, my lord, within,
No, this judgment which
possible,
has
my
been passed, although it goes from what I thought was the law, it has a different connotation, thereby bringing in the labor court within the field of 235. It's a very difficult thing, but it has been brought in.
the Supreme Court judgment, which this Gujarat also relied on, Gujarat High Court also relied on, my learned brother also relying. Lord, in that Supreme Court judgment, Lord, I have some reservations regarding its applicability, because in that Supreme Court judgment, the issue was with regard to appointment of presiding officer, who was a judicial officer. And in that context, the Honorable Apex Court has said that labor code is is a subordinate code,
Ah,
is a part of the
235
subordinate.
comes in.
Then 235 comes
Now,
in.
if 235 comes in,
This has been held by the Honorable Supreme Court in the backdrop of the facts that in that particular case, the issue was with regard to appointment of the presiding officer, which was challenged. So perhaps, my lord, we'll have to look into it. Because association challenged appointment of respondent number 2-3 who were Assistant Commissioner of Labor as the presiding officer. That was challenged, and in that context, the Honorable Apex Court has held. I have doubt, my lord, whether this will have any assistance to the petitioner. But the Gujarat High Court judgment
industrial disputes have come up. Come to paragraph 17, with due respect. Then why not DRT? What I was saying, this has a very big problem. Paragraph 17, what is being said? Means anybody who is deciding judicial comes under 235. Very difficult.
That's why, my lord, with all due respect, I have said that I have got reservation.
No,
In
I
fact,
also have, but the problem is, rightly or wrongly, that's a judgment.
that's true.
141.
My lord, I am not submitting either. Lordship will not keep my submission as a submission from the respondents. I'm
No,
just
no,
submitting
I
as an official.
also, this matter has is of great interesting value out here,
Exactly.
taking into account means then this observation will have far-reaching consequences everywhere.
In fact, in the Gujarat judgment also, my lord, apart from relying on this judgment, there were other factors.
No, no,
Like
Gujarat
Supreme Court-
judgment is on another
That-
aspect,
like
where
recruitment
the
rule was-
question involved before the full bench was whether the ministerial staff will come within the ambit of 236B. That was the issue out there. And so there the Supreme Court says, holding that.
I'm not saying about Gujar. The Gujarat High Court Division Bench judgment, which my learned brother is relying on, my lord, this is facts are almost to some extent, my lord, identical. Claim was also same by the ministerial staff of the Labor Commission, my lord, Labor Court. But here also, my lord, the Honorable Apex Court relied on the Supreme Court judgment. Sorry, Gujarat High Court relied on the Supreme Court judgment, and there were some additional factors like High Court taking a decision to bring the Labor Code within its purview by framing recruitment rule. Ministerial staffs were
included in within that recruitment rule. So there were some, my lord, implication
No,
by which
as of now, no, as of what maybe. Now, the thing is, as regards our district, we have only, that means, if that is a proposition in MACT also, we don't have control in respect to the ministerial staff,
yes, my lord.
if that be so. Because this is done under the Motor Vehicles Act.
Yes.
DRT2, we don't have anything.
So that's why, my lord, I
So-
said,
If it is the judicial service is being taken and it comes under, then why not Gujar's case come in? That is one aspect. And if Gujar's case coming, he has to be given the same parameter. What does Gujarat High Court say? I'm not bothered with that. I'm only concerned with the Supreme Court.
correct.
That I'm not, therefore, Mr. Nair has also not the occasion to show it to me also. I'm not going to
But
look into
with this
that, but the
Supreme Court judgment
fact
also-
remains out here that this has a very important ramification, and because of this paragraph, although very difficult, but then also it's law, paragraph 17
I've gone.
says the view taken by the Allahabad High Court, because Allahabad High Court held what I was thinking.
Yes.
In the case of so-and-so held that the presiding officer of a labor court does not belong to the judicial service of the state as defined in 236. The Allahabad High Court judgment has been relied upon by this court in Chandra Mohan 3. Okay, Chandra Mohan is, what is that? Relied upon? 1966. That has to be looked. For the purpose of holding that it is only the hierarchy of the original civil courts in the narrow sense headed by district judge which comes within the term of judicial service under 236. The view taken by the Allahabad appears to be too narrow a view of the term so-and-so. In Chandra Mohan's case, this court was primarily concerned with excluding from judicial service persons who held posts in services which are not exclusive here. When the service is exclusively judicial, there is no reason to exclude such judicial service from the term 236. This is a very difficult position. The High Court in the present case is justified in rejecting the narrow view taken in this judgment.
There is a catch also, my lord. It says that if the service is judicial service,
Understood.
so even
Now,
then,
if this be so,
here,
if you hold it to be a judicial service, his establishment would also be judicial service. You see, otherwise the problem. Let me explain you the problem. He will come under 235, meaning the High Court will have control. But the High Court would have no control over the subordinate, the ministerial staff. It will have a rampant problem. This happened in Kohima, Nagaland. Nagaland, what was happening? The judiciary, the district judiciary came in. There was no problem with that, with the separation of the executive from the judiciary. They came in. But the ministerial staff was controlled by the state. With the controlling of the state, they take the leave from their officials. And he can't do anything. The district judge tomorrow,
I understand.
just for example, the district judge, courtmaster, the solicitor out there, he's not there. Oh, he has taken the leave from somebody. Driver, tomorrow, the lady district judge comes out to go somewhere, the person comes out and says, no, we have taken the leave.
lordship is correct with regard to this
This
control.
has a lot of impact.
Yes.
So if this is judicial, this has also to be judicial. Otherwise it will have it. That is why Gujar, and if you see that Madhya Pradesh judgment that comes in. Otherwise, the High Court could not have
There will be
those control.
friction.
It will have a
Serious
lot of problems. You don't have him, the judicial officer also there, then it is government. So they will do all these things. But if you have him as a judicial, then the remaining, if there is no control of the High Court, then it will have a far-reaching consequences. That is another very important thing. It has such a big
I
ramification.
also feel that the control has to be there.
There is no control. Here, just for example, the presiding officer, let's take this judgment. The presiding officer under 235 comes under the High Court. But this, if we take this judgment and ministerial staff does not come in, the presiding officer cannot say that, okay, it's transfer him, so yeah, nothing.
He cannot control.
Which will
Although
happen,
industry
he
should
can't
have said
control.
that he is the
And if
appointing
you
authority.
can't control your staff, and that is an independent establishment, a labor court or an industrial tribunal is independent. And if you can't control them, and they go to some officer out there in the labor department, and the ALO gives the leave, and the district judge, of the level of a district judge, he can't control him.
Yes.
Just see that. Think about it.
Yes.
If we negate Mr. Nair's thing, all to tell you say, okay, out, which becomes difficult in view of this judgment, unless there's some other judgment which says so. Because you have to otherwise also look into it. District judiciary is another thing, the district judge is another thing to the effect. So this is a very difficult thing, because I had the occasion of facing the problem with the Nagaland judiciary.
Yes.
Luckily, me and Chief Justice Vishnu had a very active role out there. We took it up with the state of Nagaland, and I think last April, we got the last lot transferred. They were keeping 12 or 13 out of 410. 12 or 13 they were keeping. Last lot got transferred. So this is how it happened.
Look, basically, my idea is, Milord, I want to learn from this because this is also a bit new topic.
I am
for-
always learning
So-
from Mr. Nair and all. So this thing.
Other aspect, if Lordship permits me,
Control is correct. Has to see.
there's another aspect, if Lordship permits, my lord. Under the Assam Judicial Service rules, they have brought in the presiding officers of Labour Court, Industrial Tribunal, as well as MACT under the judicial service.
Yes,
Yes.
that is another thing.
Yes, yes, yes.
No, they can't. You see the ramification. If you have them, if you say that you have control and you see this, then why not control over DRT? Company Law Tribunal, NCLT. Have them. They are also judicial officers. They will also come under 235, 227, 235. They will come because they are subordinate.
Control, my lord, I go by.
There are lots
Control
of
has to be
ramifications
there.
because of the
Because
fact that they
otherwise
are
there'll be
central
serious
government.
friction.
The High Court is not doing anything. More particularly, their salary being higher. There's another catch.
Yes.
The salary is higher. They are not aggrieved. The central government salary or enhancement, all these things happens early.
Higher.
So they are not aggrieved. But it happens here. And more particularly, it happens in the other states. That's why in Nagaland and all these things, where the salary is less. Like in Arunachal Pradesh,
Is
their
higher.
salary is high.
Yes.
And they don't mind.
don't
That's for example, in the earlier matter, you could see the Advocate General came over, okay, no problem. We are also going to give the High Court order. Now the problem is I passed that order. The problem is these people will come up and say that the High Court also, some people will say we should also get it.
That's true.
That is why I did not decide the issue. I asked the Advocate General to file an affidavit and therefore I
Clarifying
filed.
this, yes.
So it is a concessional order.
Yes.
Not otherwise it will have again the problem here. And we'll see Mr. Borpujari out here again fighting tooth and nail not to give these people some amount something.
So far as control is concerned, my lord, I have filed an additional affidavit wherein the sanction of GPF advance is from the judicial department. I have at page 150, my lord. For the
Mr. Nair, there is no problem. You see, even the High Court considers it. That the ministerial people are also within its control. High Court considers it. But the fact remains that the state is not living out that.
Right.
So High Court also considers it. So they have done all these things. They also pay. They don't mind. But this is a very fine point which you have raised. And we always get these points when Mr. Nair is there.
True.
So these are fine
Absolutely.
points. So anyways, we can again hear it. This is a
Madam.
matter of importance.
I'll also go
And I
through
can't
try
dispose
to
it
assist.
just off the cuff, huh?
I'll also go through something
You
and
have to
I'll
look
try to
into it,
assist you.
Because
Yes.
this will have a lot of ramifications.
Yes,
If I
madam.
hold it,
It'll change
If
the entire
it-
structure, my lord.
if I dismiss his case also, there's a big problem.
Yes.
If I hold his case also, there's a big problem.
Yes, my lord.
So this is,
We'll assist, my lord.
Hearing remains unconclusive. List the matter again on 4th of December. You're there?
Fourth, I'll be out of station. I'll be out of station. Fourth.
Okay.
11th and
11th of December.
I have some difficulty on 11th and 18th.
Hello.
If lordship any other contingency.
Then the last week is very difficult. Anyways, we can have it on the 11th.
January.
Huh?
There will be a lot of time.
All of them.
to know all of that.
January or November.
8th of January. No, this is then I can't have it parted. We have, but anyways, this will
No,
come
it will
before
come up
will
before
come
your
down the
last
list. No, it will come, but it will come down the list. The moment I remove that parted, then it will come down the list. You want that?
No, my lord.
You say your availability is there on 4th,
My
4th of December for further hearing.
photo.
We'll see. Don't worry.
Fine.
Your junior can there, but
Fine.
this I'm not going to.
My friend is.
Fourth, my lord, I'll not be there, my lord.
Will require
11.
making it reserved.
My
I'm not going to dispose it all.
Fourth, I'll not be there, my lord. Fourth, I'll not be there.
4th, you are having problem.
Yes, my lord.
11th, he is having.
Yes.
Okay, 11th. We'll take care of it.
My friend will be there.
Yes.
Deep here.